Thank you, Alex. Welcome back to the November 6th. Oh, sorry. November 6th through 7th through 2024 board meeting. My name is Sung Oh, president of the board. Before we convene, I'd like to remind everyone present the board is a consumer protection agency charged with administering and enforcing pharmacy law, where protection of the public is inconsistent with other interests sought to be promoted. The protection of the public shall be paramount. As I facilitate this meeting, I will announce when we are accepting public comment. I have advised the meeting moderator to allow 3 minutes to each individual providing comments. 2 minutes to each individual providing comments. We'll begin with public comments for individuals attending in person in San Diego, followed by public comments by individuals participating via WebEx. This approach is necessary to facilitate this meeting. Before we get started, I would like to ask staff moderating the meeting to provide general instructions. Moderator, I believe it's Sarah today.
Correct. This is the moderator. As a reminder, public comments should be limited to the topic addressed during that specific agenda item. When public comment is requested by the board for individuals participating on WebEx, you may indicate that you would like to make a public comment by clicking the raise hand icon at the bottom row of your WebEx screen. If you're an audio-only participant, you may click *3 on your device to raise your hand. You may also indicate that you would like to make a public comment by clicking the Q&A box down at the bottom right-hand corner of your WebEx screen and typing the word comment. Each commenter will be invited to unmute themselves in turn, and they will be given 2 minutes to speak with a 10-second warning. At the end of the time, the microphone will then be muted, and we will move on to the next commenter. I'd also like to add that once you are unmuted, please give WebEx a few seconds for your audio to connect so your beginning statements are not cut off. I believe that is all my instructions.
Thank you, Sarah. I would like to take a roll call to establish a quorum. Jesse Crowley.
Licensee member present.
Morning, Jesse. Trevor Chandler. Don't think Trevor's joining. Renee Barker.
Licensee member present.
Good morning, Renee. Indira Cameron Banks. I don't believe Indira is joining. Jeff Hughes.
Public member present.
Morning, Jeff. KK Ja.
Licensee member present.
Good morning, KK. Jay Newell.
Public member present.
Good morning, Jay. Satinder Sandhu.
Licensee member present.
Good morning, Satinder. Maria Serpa.
Licensee member present.
Thank you. Good morning, Maria. Nicole Tebow.
Licensee member present, and no other people 18 years or older are in the room with me at this time.
Thank you, Nicole. Jason Wise.
Good morning, public member present.
Thank you, Jason. And I'm here. Quorum has been established. All right, we're moving right back to where we stopped yesterday. Agenda item 12, discussion and possible action related to proposed amendment to California Code of Regulations, Title 16, Section 1711, related to quality assurance programs, including comments received during the 45-day comment period. So this item is board's proposed changes to California Code of Regulations, Title 16, Section 1711, related to quality assurance requirement. In January of 2023, the board approved proposed regulation text to amend Section 1711 related to the board's quality assurance program. You may recall that as part of the board's Medication Error Reduction and Workforce Committee, this ad hoc committee took a deep dive into the issue of medication errors. Through this work, one of the action items identified was a need to update the board's QA regs that have largely remained unchanged to 2 decades. The board's 45-day comment period closed on September 23, 2024. As noted in the meeting materials, the board received a number of comments. The meeting materials include several items, including the proposed regulation text, as initially noticed, comments received during the public comment period, staff recommended responses, and recommended changes to the proposed text in response to the comments received. I note the slide being displayed shows the changes being recommended. I trust everyone had an opportunity to review this information. I have reviewed the information and agree with the staff recommended response. I note that the meeting materials and meeting slide have proposed motion language that could be used to adopt the regulation text. As I open for member discussion, I would also entertain a motion if you believe such action is appropriate. I know Maria had a comment, so I'll put you on the spot, Maria, and start with you.
I appreciate that because I was greatly impressed by one of the comments, and it really changed the way that I thought about the proposed information here. And you know, our program has always been a QA program, which is about reviewing individual events, it tries to mention a little bit about tracking and trending and patterning and those things. But when it really comes down to it, each event is reviewed in a silo, so to speak. And so if you look at, just to draw your attention, because I'm hoping that he's going to be here and provide testimony, but that was the written comments written by Andre Peters. Comment number 24, he comments about having a quality assessment plan. And for those of us that work or that are licensed under CDPH or work in hospitals, we're very familiar with the medication error reduction plan, which is a plan is very different than a program. And having a plan is a very formal process of evaluation, annual reporting of the system, the processes, and the errors that occurred during that last year, versus a program which can be very limited in just looking at one event at a time. And so I was interested in see what if the board members had any thoughts about. I know that that may be a little bit different than our original intent, but it is kind of like the next step. You know, a QA program is like high school, where I think a QA plan is like college.
So that's a really good comment, Maria. I think that I'm curious to see what other members thought. I would comment though that this is something we could at least strongly recommend to all the stakeholders to consider. But as part of the regulation, I'm a little bit unsure because this would be like like you're going from high school. I think it's like going from elementary school to college. So it's like, it's quite substantial. So just, that's my thoughts. Members, any thoughts on possibly trying to include this in as a part of the regulation? Is that what you're kind of looking at, Maria, as part of the regulation, actually to formally include this?
I think there's some opportunities to maybe not include everything that was in the comment, because that maybe is the goal, the policy goal. But I think that there may be some opportunities, like you said, if you really believe that we're still in elementary school, we need to go at a little bit more stepwise approach. We can't just go from elementary school to college. But I was thinking more that most of us are pretty much in high school with QA programs.
Yeah.
If you have one, unfortunately, there are still places that have no QA program, so that's a bad thing. But typically those that do, I think, could be stretched to grow to be more like a plan. So I think that there are probably some interim steps that we can make, and then over time, maybe reach a different policy goal. But it is a regulatory process. Regulations take a long time to get through.
Right.
So I think that it's an opportunity to take a step forward. If we're not ready to take the giant leap, at least have a discussion about the giant leap and then see what we can do for steps forward.
Sounds good. Any thoughts, members?
I agree. I think it's a great idea. I think it would add a significant burden to the workload. And so I don't know how realistic that is, because so much would be added to the plates. Probably the PIC is most likely to make sure that these sort of things are done. But I think we should maybe keep this comment in mind for the future and see how this could potentially evolve, because I do like the idea. I think it does hit the nail on the head with the intent of assessing why errors take place and what we can do to prevent it in the future. I also agree with the timeline change. I think they crossed out 1 and added 3, which I think we've had discussion about in the past about how realistic it is to keep those records. But
Thank you, Jesse. Members, September?
I was going to comment that I, just like the previous comments, I agree that this is a good plan. And most, I think, like some of the pharmacies already have a system that track possible errors that could happen, and incorporating into when they, even though there's no error there, when they're assessing it, what could have been prevented, have the plan to mandate it. Some pharmacies may not have the system in place to this extent where they're monitoring possible errors. that could happen, and that could could be burdensome. That I agree with that. And we should get this out and then see how it does, assess it, and can keep this comment in mind, and down the road we can revisit again.
Okay. Members, any other thoughts?
President O, can I jump in?
Absolutely, Nicole. As I said
Um,
yesterday, just please jump in.
I know
'cause-
it's so awkward though, but thank you. Um, I definitely appreciate the idea, but I think we have to keep in mind the wide variety of settings we're talking about. Yeah, that totally makes sense in a hospital and a clinic in these large places. But there's a lot of pharmacies that have 1 or 2 employees. And then to make them necessarily go through a process that's meant for like a hospital or something like that might be really burdensome, and you're taking them away from, direct patient care. So I don't think it's a bad idea, but I think there has to be some knowledge that, college isn't for everyone. So it might not be the right option. I think the other thing we may want to think about is a lot of places already do this,
Mhm.
and maybe it would be worth asking that question of people if we do another survey in the future. Like I know our organization, we do root cause analysis, we do near miss, we do like all of this because we have the clinic. We have like a whole committee that reviews everything. And I think you'll find a lot of clinics, a lot of hospitals, a lot of settings already are doing this work. It doesn't necessarily get reported to the board because it's not required, but we may be being duplicative or make people change processes they already have if we dictate that. So it might be helpful to find out who already does this.
Thank you, Nicole. Great comment. Maria?
So I'm glad we're having this conversation, and I really do appreciate Jesse's and Nicole's comments, especially your last comment, college isn't for everyone. And I think that that is really important. That's one of the reasons why I do appreciate the representation on the board, that we all have different vantage points of the different practices of pharmacy. So I would suggest, because this is the 45-day comment period and that we are well on the regulatory path, it's not the time to muddy the waters, but to move forward and perhaps have this be an agenda item on a future committee discussion for future enhancements to how we use quality assessment.
Thank you, Maria. And I think it's actually good approach that way because, as you all know, we are going to start having mandatory error reporting hopefully soon, sometime starting in next year. And combined with that, with this update, I think we're going to be in a very good position to have some good understanding of what's going on. I think that 3 years is very helpful and useful to at least be able to have some visibility of the errors that occurred. Again, with a just culture in mind. I cannot emphasize that enough, that I think it's really important for us to keep that in mind of just culture. With that, any members want to then make a motion to move forward? Jesse, unless you have.
Yeah, I'll make the motion to accept the proposed language. Do I have to read the whole thing?
Yes.
Okay.
Our,
I will have to pull it up. Hold on.
it's, oh, okay.
I know, if you have it in front of you. Okay, so I move to ratify the modifications to the regulatory text published during the second 15-day comment period. Oh, that's the wrong one? Oh, this is 11. This item.
Oh, that's something. Oops.
Technical difficulties.
This one? This is the rewritten one.
Oh, here we go. Okay.
It was updated.
So I move to accept the board staff's recommended comment responses, approve the recommended updated modified text as recommended by staff for a 15-day comment period. If the board does not receive any comments providing objections or adverse recommendations specifically directed at the proposed action or to the procedures followed by the board in proposing or adopting the action, authorize the executive officer to take all necessary steps to adopt the proposed regulation at section 1711 and complete the rulemaking process. Finally, delegate to the executive officer the authority to make technical and non-substantive changes as may be required by the control agencies to complete the rulemaking file.
Thank you, Jesse.
Try that in one breath.
Do we have second?
I second.
Thank you, Maria. With the motion and second, and we're ready for public comment in San Diego. Public comment ready for WebEx.
All right, this is the moderator. We are now open for public comment on WebEx for agenda item 12. If you would like to make a public comment on this agenda item, please use the raise hand icon on your WebEx screen, or if you're an audio-only participant, you may press *3 on your device to raise your hand. You may also use the Q&A feature to indicate that you would like to make public comment. And it looks like we do have a couple requests. First, I have Keith Yoshizuka, and Keith, you'll be given 2 minutes to speak with a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Keith Yoshizuka. I speak in favor of the suggestion by Dr. Andre Pearson. Having been a PIC for, 40 years, it's not that difficult to develop a plan. You just document the errors on an Excel spreadsheet. Periodically, I used to do it quarterly. I review the type of errors that occurred, both quarterly, semi-annually, annually, and you can detect a trend, and you sort it by type of error, and it's amazing what you could find out. So I strongly speak in favor of incorporating that into the regulation. Thank you.
Thank you for the comments, Dr. Yoshizuka. Oh my God.
All right, this is the moderator, and it appears our second request is not for this agenda item. At this point, would you like me to close the Q&A feature?
Yes, please. I believe we have in-person comment. Okay. Okay. Oh, go ahead, Sean. Just sometimes I'm a little too quick, so just raise your hand so I know you're coming up. So I'm sorry. I'm not trying to skip anyone.
Thank you so much, and I appreciate for all the comments. Sean Kim from California Pharmacists Association. I believe this is also going along with the compounding updates, especially with the USP Chapter 1163 about the QA and QC. As you mentioned, there are many different practice settings that has been familiar with the concept of QC and QA, but and even with providing CAPA, correctiveness and preventive actions, but also we also have to be acknowledged that there are other pharmacy practice settings that are still kind of in a learning phases from whether we are comparing it to elementary to college. But I believe this is a great minds that we're thinking of to advance the pharmacy practicing. And I'm really hoping we are continuing engaging this concept of QC and QA. Thank you.
Thank you for the comments, Dr. Kim. Any other in-person? Seeing none, we are ready for a vote. Members, any comments before we vote? Okay, Jesse, how do you vote?
Yes.
Thank you, Jesse. Renee?
Yes.
Thank you, Renee. Jeff?
Yes.
Thank you, Jeff. KK?
Yes.
Thank you, KKJ.
Yes.
Thank you, Jay. Satinder?
Yes.
Thank you, Satinder. Maria?
Yes.
Thank you, Maria. Nicole?
Yes.
Thank you, Nicole. Jason?
Yes.
Thank you, Jason. And I vote yes. The motion passes. Next, agenda item 13, Organizational Development Committee. Moving to the agenda item 13, the Organizational Development Committee report. This report is for information only, so I'll keep my comments brief and open up for board and public comments at the end. The meeting materials include updated information on the board's budget for fiscal year 23-24 and for the new fiscal year, which began on July 1st. The board's authorized expenditures are anticipated to be about $36.3 million this year. The board's fund condition indicates that it is projected that the board fund will slowly decrease. According to the report provided by the DCA, the board's fund currently has 6.3 months in reserve. As a reminder, under the Business and Professions Code Section 4400P, the board shall seek to maintain a reserve equal to approximately 1 year's operating expenditures. As the board's new fee structure take effect in January 2025, we'll continue to monitor the fund and, if necessary, to make adjustments in future years. The board member attendance and mail vote information is included in attachment 2 and 3. I'm truly grateful to everyone for their time and commitment to protecting California consumers. Moving to the personnel update, the board currently has 13 vacancy staff positions. Recruitments are ongoing. I receive regular updates on recruitments as part of my weekly meetings with the executive officer and monthly as part of our organizational development committee meetings. Lastly, the proposed meeting dates for 2025 is attached, but some dates are subject to change. We'll post that up on and send to all the members as soon as we are able to finalize all the meeting dates for 2025. Can't believe 2024 is almost over. Members, do you have any comments on any of the items included in this report? I'm seeing none. Any public comment in San Diego? Seeing none, we're ready for public comment in WebEx. Sarah?
All right, this is the moderator. We are now open for public comment on WebEx for agenda item 13. If you would like to make a public comment on this agenda item, please use the raise hand icon on your WebEx screen. And if you're an audio only participant, you may press *3 on your device to raise your hand. You may also use the question and answer feature to indicate that you would like to make public comment. And at this time, it appears there are no requests for public comment on this item. Would you like me to close that Q&A panel?
Yes, please. Thank you. All right, next is agenda item 14, Executive Officer Report. I will turn the meeting over to Anne for a brief report. Anne?
Good morning. Thank you. Just a few items included in the report. The NABP District 6, 7, and 8 meeting was recently convened in New Mexico, so there's a bit of brief information in the meeting materials about that. President O was reelected as the district treasurer. Congratulations again. It is anticipated that California will host the meeting in 2027. We will keep everyone apprised of that. The annual meeting for NABP is scheduled for next year in Florida, and we do believe that there may be some potential resolutions that align with some of the actions that the board is also considering at the California level. Any questions on that? If not, I'll continue to proceed. So the only other thing is the board's Legislation and Regulation Committee only meets twice a year. And so with that, then the members don't necessarily always receive an update on the various stages of the various regulations and the stages that they're in. So that information is also included in the memo to members. And that's my report. Thank you, President O.
Thank you, Anne. It was a lot quicker than I thought you're going to go. So we're ready for public comment.
Member comment.
Oh, yeah, sure. Member comments? Yeah.
Yeah, just a quick question for you, Anne. On number 11 of the regulations, which is the self-assessment for outsourcing, I know that sometimes the regulatory process does move slowly, but it seems like that we passed it as a board in 2022, but DCA just recently returned it to the staff. Is there any update on the timeline so we can get that self-assessment form out?
So sometimes with the more complex ones, such as outsourcing, where it's kind of a different area, there is a lot of back and forth. So what this indicates is the most current status. Happy to check back in with staff. We do have a couple of other ones that we're focusing on that have time-specific things because they're in the full rulemaking process, like the formal rulemaking. This one is not yet, but I'm happy to provide an update at the December meeting with projections.
Thank you.
Thank you, Maria. Ready for public comment in San Diego.
Good morning, Lori Wamsley. Not on behalf of Walgreens, on behalf of myself. So I'm currently serving as the chairperson of NABP District 8, and I just wanted to get up here and publicly thank Dr. O for his assistance this year in the planning of the district meeting. That is one thing that you left out of your report. Sung was amazing to work with and did a lot of work on his own personal time to make sure that the district meeting was successful. And I am very glad that he will continue to serve in the role as treasurer because He's certainly made our district stronger. So thank you. I just wanted to make sure that
Thank you,
everybody knew
Lori.
what you did.
Thank you, Lori. Any other comment? Okay, we're ready for comment WebEx.
This is the moderator. We are open for public comment on WebEx for agenda item 14. If you would like to make a public comment on this item, please use the raise hand icon on your WebEx screen, or if you're an audio-only participant, press *3 on your device to raise your hand. You may also use that Q&A feature down at the bottom right-hand corner. All right, and seeing no requests for public, oh, I apologize, we do have one. Dania Cerrone, and Dania, you'll be given 2 minutes to speak with a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Good morning, everyone. My name is Dania Cerrone. I am a registered dietitian at Stanford, but I'm speaking for myself, not as a representative of Stanford Healthcare. I have a condition called pernicious anemia, and pernicious anemia is an autoimmune condition that prevents my body from absorbing vitamin B12. And without adequate...
I apologize. This is the moderator. This is not related to agenda item 14. I think this is related to agenda item. Do you mind holding your comment until we get to the agenda item?
Yeah.
No worries. Thank you.
Yep.
Thank you. Thank you, Sarah.
All right. And then it appears that we don't have any other requests for agenda item 14.
Thank you, Sarah. Thank you. Yes, please. Thank you, Sarah. All right, we're ready to go to next agenda item 17, discussion and possible action related to proposed regulations, Title 16 California Code of Regulations, repeal of section 1708.3, 1708.4, 1735 at sequence N 1751. Addition of section 1735, 1736, 1737, and 1738 related to compounded drug preparations, hazardous drugs, and radiopharmaceuticals, including educational presentations by board counsel and staff on federal law and background information and consideration of comments received during the 45-day comment period and regulation hearing. We're going to take about quick 5-minute break so that presenters can set up. And we'll come back at, let's come back. Why not 8 minutes? 9:35. We'll come back at 9:35. Okay, as I said, next on our agenda is review of comments received in response to the board's proposed regulation. Oh, you know what? I should take a roll call. Yes. Okay. All right. Jesse?
Here.
Thanks, Jesse. Renee?
Present.
Thank you, Renee. Jeff?
Here.
Thank you, Jeff. KK?
Present.
Thank you, KK. Jay?
Here.
Thank you, Jay. Satinder?
Present.
Thank you, Satinder. Maria?
Here.
Thank you, Maria. Nicole?
Here.
Thanks, Nicole. Jason?
Here.
Here. Thank you, Jason. And I'm here. Quorum has been established. Next on our agenda is a review of comments received in response to the board's proposed regulations regarding sterile and non-sterile compounding, hazardous drugs, and radiopharmaceuticals. It is clear from the meeting materials that there is significant engagement from interested stakeholders on the proposed regulations. And as you recall, during our September meeting, members requested additional education on this complex area of practice. Before we resume our discussion and consideration of the comments received and the staff recommended proposed text, I'm going to turn the meeting over to DCA Counsel Corinne Gartner and the board's executive officer, Ann Sodergran. The floor is yours, guys. They're over there on the side table.
Okay. Can everyone hear okay? Great. Okay, so yes, Ann and I are going to tag team a little bit here. I'm going to start with a presentation on the federal and California requirements for human drug compounding. Next slide, please. Okay, we've got the obligatory disclaimer here. Just again, this presentation is a brief summary and overview of federal law and guidance and California state law governing human drug compounding. Of course, compounding pharmacists themselves should be consulting their own attorney or other resources to make sure they're in compliance. Next slide, please. So I thought I'd start with just kind of a 30,000 foot level. overview of general information and background on compounding for the benefit of some of the newer board members. So compounding, of course, is the longstanding pharmacy practice of mixing, combining, or altering ingredients. It may involve altering an existing drug product or creating a new drug product. Compounded drugs can serve patients, of course, whose clinical needs cannot be met by FDA-approved drugs. However, they may pose a higher risk to patients because they are not FDA-approved, and compounding pharmacies may be exempt from certain manufacturing requirements. Next slide, please. Compounded drugs can be made for a variety of uses, including topical, oral, injectable, or inhalable. Drugs administered orally or topically present less danger to patients from residual contaminants than drugs injected or inhaled into the human body. This is because drugs injected or inhaled into a patient's body bypass the human body's main defense mechanisms to filter out residual impurities. So consequently, the acceptable levels of contaminants in injectable and inhalable drug preparations are lower than for topical or oral drugs. And injectable and inhalable preparations have to be sterile for this reason. And sterile, injectable, or inhalable drug preparations compounded from non-sterile ingredients generally considered to be a higher risk preparation due to the route of administration. Next slide, please. Wow, I can actually hardly see that slide, but okay, I think we're on the right one here. Okay, compounded human drugs are not approved by the FDA, and the FDA does not review such drugs to evaluate their safety, effectiveness, and quality before they're administered to patients. However, the FDA does have a role in approving the ingredients that may be used in compounding human drugs. And when it comes to regulation of pharmacies and pharmacists that are engaged in compounding, it's primarily the states that are doing that. Thus, pharmacists and pharmacies engaged in compounding, whether sterile or non-sterile, are subject to both federal and state law. Okay, pivoting now to an overview of the federal law on compounding. So similar to other areas of pharmacy law, there is a federal overlay to compounding by state licensed pharmacists. Violation of federal law could subject licensees to potential enforcement by federal agencies, as well as to discipline of their state-issued licenses or permits. And throughout this presentation, there are a number of links to other resources. We've got a first one here. There's a very helpful section on the FDA's website that's devoted solely to human drug compounding with a lot of guidance and information and other resources. So that link is here. Okay. So continuing with our federal law overview and the need for an exemption for compounding. So generally, compounding a substance would result in a new drug that would require FDA approval and could result in violations of federal provisions, including new drug approval requirements, without an exemption. Section 503A of the Federal Food, Drug, and Cosmetic Act, also referred to as the FDCA, provides exemption from certain provisions of the FDCA. So noncompliance with any of the requirements of the 503A exemption could result in violations of one or all of these statutory provisions or of other provisions of the FDCA. Okay, so to look in a little more detail at a summary of the 503 exemption itself, 503A generally provides an exemption from the following provisions of the FDCA for drug products compounded by a state licensed pharmacist or state licensed physician. First, Section 503A2B, concerning the requirement to comply with current good manufacturing practice. Second, Section 502F1, concerning the labeling of drugs with adequate directions for use. And 3, Section 505, concerning the new drug approval process. The 503 exemption does not, however, provide an exemption from other unenumerated provisions of the FDCA. For example, the prohibition against distribution of adulterated drugs set forth in Section 301 of the FDCA. The sections of the FDCA cited here give the definition, the federal definition of adulteration. So a drug shall be deemed adulterated if it consists in whole or in part of a filthy, putrid, or decomposed substance, or if it has been prepared, packed, or held under insanitary conditions, whereby it may have been contaminated with filth, or whereby it may have been rendered injurious to health. I think it's worth pointing out that one insanitary condition that FDA has identified, and this is set forth in one of the guidance documents that we'll talk about later, but it's the FDA Guidance for Industry on Insanitary Conditions at Compounding Facilities that was released in November of 2020. So in that guidance document, one of the insanitary conditions that the FDA pointed to was using ingredients that have or may have higher levels of impurities compared to compendial or pharmaceutical grade equivalents. For example, ingredients with potentially harmful impurities, ingredients labeled with not for pharmaceutical use or an equivalent statement. So section 503A(b)(1) contains the specific substantive requirements to qualify for the exemption. In summary, drug products may be compounded using bulk drug substances, that is APIs, that 1, comply with the standards of an applicable USP or NF monograph, if a monograph exists, and the USP chapter on pharmacy compounding. 2, if such a monograph does not exist, are drug substances that are components of drugs approved by the FDA. Or 3, if such a monograph does not exist and the drug substance is not a component of a drug approved by the FDA, the substance appears on a list developed by the FDA through regulations. So another guidance document that we're going to talk about in more detail in a minute, the 2017 FDA interim policy. In that document, it states a bulk drug substance that is not the subject of an applicable USP or NF monograph or is not a component of an FDA approved drug cannot be used in compounding unless it appears on a list promulgated as a regulation. So again, under federal law, we've got 3 paths, and those are the only ones available for the ingredients to be used in compounding. Okay, so regarding the third prong of that list we just talked about, which is the list developed by the FDA through regulations, sometimes referred to as the 503A bulks list. This is a regulation that's set forth at 21 CFR section 216.23. This final rule was published on February 19th, 2019. And it basically does 3 things. It establishes the criteria for evaluating substances for future inclusion on the 503A bulks list. It places 6 substances on the list, and it identifies 4 other substances that were evaluated by FDA and not included on the 503A bulks list, such that these substances cannot be used in compounding under any circumstances. So the rule also notes that additional substances are under evaluation and may be added to the 503A bulks list through subsequent rulemaking. So on the slide here, I just grabbed portions of the actual 503A bulks list regulation. Part A of the regulation, which appears very small on the left side up there, lists the 6 approved substances. And you'll note that 5 of the 6 are approved for topical use only. And then I also wanted to highlight paragraph D of the regulation, which appears on the right side up there, as I think it gives some insight into the FDA's view of the safety and efficacy of drug products that are compounded with these substances. And I'll just read it out because, again, it's very small. So based on evidence currently available, there are inadequate data to demonstrate the safety or efficacy of any drug product compounded using any of the drug substances listed in paragraph A of this section, or to establish general recognition of the safety or effectiveness of any such drug product. Any person who represents that a compounded drug made with a bulk drug substance that appears on this list is FDA approved or otherwise endorsed by FDA generally or for a particular indication will cause the drug to be misbranded under section 502A and or 502BB of the FDCA. Next slide, please. Okay, I think it's also worth pointing out, so there's a very extensive preamble to the final rule, this regulation. So in the part, section 5 of the final rule that's entitled Comments on the Proposed Rule and FDA Response, FDA clarified that it interprets the term an applicable USP or NF monograph to refer to official drug substance monographs, not dietary substance monographs. And again, there's a quote from the regulation there, but I'll just read it out. USP monographs for dietary supplements can differ in significant ways from USP monographs for drugs because of the differences between dietary supplements and drug products. For example, dietary supplements are intended for ingestion only, and the standards contained in the USP dietary supplement monographs are likewise intended for dietary supplements that will be ingested. The standards are not appropriate for use in compounding drug products that may have different routes of administration, for example, intravenous, intramuscular, topical. In addition, the USP limits for elemental impurities are different for drugs and dietary supplements. Furthermore, the bioburden allowable for dietary supplements is considerably higher than that allowed for drug substances. Relying on the standards of a dietary supplement monograph for a substance that will be used in compounding drug products could therefore put patients at risk. Next slide, please. So as part of the FDA's evaluation of substances for possible inclusion on the 503A bulks list, again, that's the actual promulgated regulation, the FDA must convene and consult with the Pharmacy Compounding Advisory Committee, the PCAC. So the PCAC recommendations are not binding on FDA, but rather FDA considers the PCAC's advice and then makes their own independent judgment regarding whether particular substances should appear on the 503A bulks list. And it's worth noting as well that FDA also has to consult with USP when promulgating the regulations. Okay, so moving now, we've talked about the statutory provisions in 503A, we've talked about regulations that have been promulgated under it. And now we're going to talk a little bit about FDA guidance that's been released over the years. So FDA has issued a lot of written and sometimes changing guidance on human drug compounding. And again, there's a link there that has some more specific information. So some of the key guidance documents that we look at include the three listed here. There's a general publication on pharmacy compounding of human drug products from 2016. There's the interim policy on compounding using bulk drug substances under 503A that was released in January 2017. We referred to that earlier and we'll talk about it a little bit more next. And then there's the unsanitary conditions at compounding facilities guidance for industry released in November 2020, which we referred to earlier as well. Next slide, please. Okay. So diving a little bit into the interim policy. So this guidance document sets forth FDA's non-binding interim policy concerning compounding using bulk drug substances while the FDA updates the 503A bulks list, which again, it last revised in 2019. So the policy itself states that the purpose of releasing the policy was to avoid unnecessary disruption to patient treatment while the agency considers the bulk drug substances that were nominated with sufficient support to permit FDA to evaluate them. So part of what the interim policy does is it provides for ongoing categorization of nominated bulk drug substances into three categories. And here we have a description of each of the categories. So category 1 are substances that may be eligible for inclusion on the 503A bulks list, were nominated with sufficient supporting information for FDA to evaluate them, and do not appear to present a significant safety risk. Category 2 are substances that have been identified by FDA as presenting a significant safety risk, pending further evaluation. And category 3 are substances that may be eligible for inclusion on the list, but were nominated with insufficient supporting information for FDA to evaluate them. So the current list of all the substances in these different categories is posted on the FDA's website, and the link is here, and they do update it from time to time. So under the interim policy, FDA does not intend to take enforcement action for otherwise impermissible compounding of a drug product from a bulk drug substance in category 1, provided that certain conditions are met, and those conditions are detailed out here. It's basically that the bulk drug substance was manufactured by an establishment registered with FDA, is accompanied by a valid certificate of analysis from the entity that originally produced the bulk drug substance, and provided also that the drug compounded from the bulk drug substance is compounded in compliance with all the other conditions of Section 503A. So FDA will not, however, exercise enforcement discretion for drug substances in categories 2 or 3. Substances in those categories cannot be used in compounding, even on a temporary basis under the FDA interim enforcement policy. So I do think it's worth spending a little bit of time just to emphasize that the FDA's interim policy regarding Category 1 substances is an enforcement discretion policy. So this doesn't mean that FDA has approved or authorized the compounding of Category 1 substances, or that FDA has stated that compounding with these substances is safe in every instance. It was noted earlier that FDA changes its compounding guidance from time to time, and the quote that is in very small text on this slide is actually from a draft guidance document that the FDA released pretty recently in December of last year. And this is a draft guidance document pursuant to which it proposes to revise the current interim policy from 2017. And among other changes, that draft guidance proposes to cease categorizing newly nominated substances. But the quote that's up here talks about FDA's practice of preliminarily, assessing documents when they're, or substances rather, when they're deciding how to categorize them. And basically what they say is, it's FDA's practice to preliminarily assess whether the substance appears to present significant safety risks, such that it should be placed in Category 2. However, some risks may not be apparent until FDA conducts the complete evaluation in accordance with the established criteria. So they may, for example, uncover safety risks or effectiveness concerns, or concerns about the physical and chemical characterization of the substance that could place patients at risk. These concerns may not be apparent until FDA and other experts conduct an in-depth review of the substance for consideration on the 503A bulks list. Next slide, please. Okay, so the next few slides, just a little bit of giving an example of two Category 1 substances that we've heard a lot about at recent meetings. These are methylcobalamin and glutathione. So neither of these substances has a USP drug monograph. The only USP monograph for these substances are USP dietary supplement monographs. So both of these substances have been nominated for inclusion on the 503A bulks list. Both have been put on the Category 1 list and are currently under evaluation by the FDA for whether or not they're going to be put on the final 503A bulks list. So thus, both substances are subject to FDA's interim enforcement policy for Category 1 substances and other provisions of the FDCA. Okay. Regarding methylcobalamin specifically, in a briefing document prepared by the FDA for the June 9th, 2021 meeting of the PCAC, again, that's the advisory committee that they consult with when they're determining, whether or not to put substances on the final list. So the FDA recommended against including methylcobalamin on the 503A bulks list. And the quote here is from that briefing document. The link is provided so you can look at the entire multi-hundred-page document if you like. But basically, this quote says, methylcobalamin is, their conclusion about methylcobalamin. It's found in food, it's a dietary ingredient in dietary supplements, so exposure from oral ingestion appears to be safe. However, the safety of methylcobalamin administration by intramuscular, subcutaneous, or intravenous injections or infusions for a wide variety of uses, as currently promoted online by clinics and compounding pharmacies, is not supported by adequate data. Based on the information the agency has considered in balancing the 4 evaluation factors, the lack of effectiveness data and safety data for use of injectable products in patients weighs against methylcobalamin being added to the 503A bulks list. Next slide, please. Similarly, in a briefing document prepared by the FDA for the June 8th, 2022 meeting of the PCAC, the FDA recommended against including glutathione on the 503A bulks list. And here's what they said in their conclusion. The safety profile of glutathione includes serious safety issues. For example, anaphylaxis, hypersensitivity, hepatotoxicity, severe wheezing, and breathlessness. Thus, glutathione injections and glutathione inhalation preparations, which provide rapid, irreversible exposure, are not recommended for addition to the 503A list due to safety concerns. Based on the information the agency has considered in balancing the 4 evaluation factors, the lack of effectiveness data and safety data for use of products in patients weighs against glutathione being added to the 503A bulks list. And I'll just note as well that in its preliminary evaluation of this substance, FDA looked at 24 different uses of glutathione, including many that we've heard about in recent meetings: asthma, chronic lung disease, oxidative stress, inhibition of chemically induced carcinogenesis, and treatment of heavy metal poisoning. And they concluded, and I'm quoting again from the same briefing document, there is either no available information or insufficient evidence of effectiveness of glutathione in association with any of the nominated uses. Next slide, please. So ultimately, the PCAC voted to recommend the inclusion of both substances on the 503A bulks list, although those votes were not unanimous. And as noted, the FDA is not bound by the PCAC recommendations, and they're still making their own independent evaluation, and their decision on both substances is still pending. Okay, so moving quickly, I'm almost done here, but just wanted to highlight a few things about California law as it relates to human drug compounding. I think it's always prudent to start with Business and Professions Code 4001.1, which is the board's consumer protection mandate, mandating that protection of the public shall always be the highest priority for the California Board of Pharmacy. Next slide, please. Here, and again, I apologize, but those quotes are extremely small. These are just a couple other citations to California law, and I'll just point out Business and Professions Code 4126.8, which states that the compounding of drug preparations by a pharmacy for furnishing, distribution, or use in the state shall be consistent with standards established in the pharmacy compounding chapters of the current version of the United States Pharmacopoeia National Formulary, including relevant testing and quality assurance. The board may adopt regulations to impose additional standards for compounding drug preparations. And then we also have 4342A quoted here, as well as 43010. Next slide, please. So similar to federal law, California law and the Health and Safety Code also prohibits the sale, delivery, or giving away of a new drug that has not had a new drug application approved under Section 505 of the FDCA. And as a consequence, the delivery of a new drug that does not comply with the Section 503A exemption from Section 505 approval would violate both federal and California law. And also, like federal law, California law makes it unlawful for any person to manufacture, sell, deliver, hold, or offer for sale any drug that is adulterated. And we've got the citations there for the Health and Safety Code definitions of adulterated, which are very similar to the federal law definitions. So in California, unlike the FDA, which has released, as we talked about, the interim enforcement policy, the board has not issued guidance declining to enforce state law concerning compounding with substances that are not permitted under Section 503A. So the proposed new regulations that the board has been discussing over the past years and past few meetings would create a pathway in state law to expressly allow Category 1 bulk drug substances to be used in sterile compounding under specified conditions. And there are citations there to the proposed text in the proposed regulations that specifically address this. Since Category 1 substances lack a USP or NF drug monograph, they also lack a recognized uniform sampling and testing standard for use in sterile drug compounding. So consistent with the board's public protection mandate, the conditions set forth in the proposed regulations include sampling and testing requirements to help ensure that the specific bulk substances being used are pure and appropriate for the intended route of administration. And this is my last slide. I just thought that it was worth recapping the FDA statement from the preamble to the 503A bulks list regulation that we talked about earlier. Really just highlighting this again because I think it explains the difference between dietary supplement monographs and drug monographs and why that matters to the FDA from a risk perspective as well as a patient protection perspective. And that concludes my presentation. So unless there's any questions from the board that you wanted to address at this time, I'll turn it over to Anne.
Just want to make sure I make an announcement. I'm planning to take a break at 10:45 a.m. Just so our members can get some things ready. And then we're going to probably take lunch around 12:30ish. So, but 10:45 will be a hard break. So we're going to take a break at 10:45. Just wanted to make sure everyone's aware.
Is it open for comment?
Oh, yeah. You want any questions?
Oh, I did a little bit of my own reading in between last and this meeting, and I think this is very well summarized presentation. I think everything that one needs to know, at least it has all the headlines here. So I congratulate on that. Thank you.
That was helpful.
Also, I'd like to add, it was very helpful, very clear. I wish that I had that information months ago. It really could help in wrapping my head around all this stuff, trying to learn it. Is there a chance that you could share the presentation with board members?
Yeah.
Yeah, we'll be posting both of them online and we'll send out to everybody because some of them are eye charts.
I want to express that's a lot of research and very concise. It was very helpful. Some of those slides just make it answer most of the questions there.
Great.
Yeah, I also want to express the same. Corinne, thank you so much for that because the FDA regulations are not as how should I say? There's just a lot there, right? And it's very legalese, right? So it's just really important to lay it out. So I appreciate you did a very excellent job at kind of categorizing, especially as we bifurcate into our 503A mostly discussion, right? Because we're not talking about 503B.
Right.
So thank you so much.
Absolutely.
Thank you, Corinne. Okay. Anne?
So that's a lot of pressure to follow, Corinne. I'm just saying, that's not fair. Should have gone first. Okay, so thank you. So with Corinne providing some of the foundational information specific to provisions of state and federal law, I am going to be, covering some of the things that she already covered as well. As I begin, I do want to highlight that I'm providing background information based on both information that's contained within the initial statement of reasons, background on the board's public protection mandate, and the process that the board uses to develop regulations, addressing some of the actions by the FDA and other public information. I believe that it's really necessary to note that an individual or an entity that's engaging in compounding cannot look at a single source to understand the legal requirements for compounding. This is just a very complicated area of practice. So the other thing that I just want to quickly state as well is I want to thank everybody, not only for the opportunity to present today, but for everybody that has engaged in this process. It has really highlighted that there's an opportunity to provide some further information and some education. Much of the information that I'm providing today is contained in the board's initial statement of reasons that is posted on the board's website as part of the rulemaking file. I would also like to thank in advance the attorneys and the experts and my colleagues at some of the different agencies who have been very gracious with their time as I prepared for this presentation. So I believe it's important to remind everyone, similar to as Corinne did, the board's statutory mandate, and it's displayed on the slide. And as noted on the slide, public protection shall be the highest priority for the board. Whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. I believe it's important to highlight competing interests and public comments sometimes may urge the board to take a specific action, but ultimately it is you, the board. You are required in your decision-making to determine what protection of the public demands for all Californians. If we can go to the next slide, please. So the board has sought to educate interested parties about this complex area of practice through its public discussions throughout the development of and through the rulemaking process. Recognizing that not everyone can participate in all meetings, and in response to some comments that appeared to suggest maybe some inaccurate information, the board took the unusual step of releasing information to provide education and links to federal law, as well as to answer some common questions. If we could go to the next slide, please. So as an example, as displayed on this slide, some information circulating in the public domain suggests that the board's proposed regulations ban the compounding of substances such as glutathione and methylcobalamin. As displayed on this slide, the board highlighted that the proposed regulations aim to align with the federal law and national standards. As we have previously discussed, and as was emphasized by Corinne, federal law establishes requirements for the types of substances that can be used in compounding to meet the requirements established in Section 503A. Next slide, please. So shown on this slide is a portion of the board's proposed modified text that, if adopted, would establish provisions for the compounding of substances such as glutathione and methylcobalamin. I want to highlight that the proposed text displayed on this slide is a significant expansion from the text originally noticed and reflects the board's consideration of public comments received thus far during the rulemaking process. If we could go to the next slide, please. The board also released information about why the board is making the changes to the compounding requirements. It is difficult to summarize the why totally in a few sentences. To gain a full understanding of the why, someone will need to read the initial statement of reasons, the underlying data, FDA actions, compounding alerts, etc. As I stated at the beginning of my presentation, this is a very complex area of practice. Next slide, please. This slide provides an example of a compounding alert from the FDA, highlighting its concerns with using dietary-grade glutathione to compound sterile injectables. Next slide, please. To read from a portion of the alert, ingredients not intended for use in compounding sterile injectable drugs can be harmful when administered to patients because they may contain impurities and contaminants, including endotoxins. Next slide, please. I realize that some individuals participating in board meetings may not be totally familiar with the rulemaking process, so I would like to assure interested parties that should the board take action today to further modify the proposed text as recommended, there will be another formal comment period which will provide interested stakeholders the opportunity to formally engage in the rulemaking process. This stands in contrast to providing public comments during a board meeting that is not designated as a public comment period. Should the board move forward with further amendments to the text as recommended, any comments received will be considered by the board at a future meeting as required by the law. Next slide, please. In addition to the common questions and answers previously released in September, I'm aware of some information circulating that suggests there is no oversight of the board and its rulemaking activities. This slide displays a number of control agencies with oversight over the board's rulemaking activities. Next slide, please. Pivoting now, I'm going to just provide a very brief history on the board's compounding regulations. So based on my research, the board's first compounding regulations became effective in 1986. Next slide. In response to patient harm and death of patients,
The board updated its requirements for sterile compounding through legislation in 2001. As you will note on this slide, based on a compounding incident, 13 individuals were hospitalized and 3 died. Next slide, please. Compounding regulations were further amended in July of 2010 and most recently in 2017, with some minor changes to some portions of the regulations becoming effective in 2019. Just a quick note that in 2015, the board actually did a significant work for compounding regulations, withdrew those, and then pursued the action that's displayed on the slide in 2017. Next slide, please. I talked at the beginning about the board's consumer protection mandate, protection of the public being the highest priority for the board. I wanted to share some previous examples of patient harm and death related to compounding, and I want to just note these are not the only examples available. Next slide. So the board and the FDA are not the only entities that highlight patient safety concerns. The Institute for Safe Medication Practice in 2017 highlighted a death of a pediatric patient involving an oral liquid suspension. Please note the example involves non-sterile compounding. Next slide, please. The tragedy from compounding practices involved at the New England Compounding Center also serve as a reminder about the significant consequences of poor compounding practices. For those who may not be familiar with this issue, NECC compounded and sent products to a number of states. The CDC reported in January of 2013 that 678 people in 19 states had contracted a fungal disease. At that time, 44 people had died. As of March 2013, 84 people had died and 720 were being treated. Final figures actually reported higher numbers. Next slide, please. So pivoting now to the board's efforts to develop the current proposed regulation text. Next slide, please. In the interest of time, I cannot discuss this in great detail. I will note that the board and its committees perform all of its policymaking activities in public meetings. All of the information is available on the board's public website. I would encourage anyone interested in learning about the process to review all of these items that are easily accessible, as I indicated, on the board's website. Next slide, please. As I mentioned, the initial statement of reasons, which is publicly available and posted on the board's website, will provide an explanation for each of the proposed changes. It is not possible during this presentation to provide all interested parties with the justification for each proposed change. I would encourage people that are interested in learning more to read this and the other documents posted on the board's website. The board's public rulemaking record is also available for public viewing in the board's office. Next slide, please. The initial statement of reasons also details out underlying data relied upon in establishing the proposed text. I do note that based on a number of the public comments received, I believe it may be appropriate to release an amended initial statement of reasons during a future public comment to ensure all interested parties have a clear understanding of the information relied upon. Next slide. It is important to note that many of the provisions included in the proposed regulation text are existing requirements now. The text may look new, but that is because the board is restructuring its regulation structure to align with the USP chapters. This slide provides an example of current and proposed text related to the definition of essentially a copy, with some slight non-substantive changes to the grammar. Next slide. As another example, this slide shows the current requirement regarding the self-assessment process. And if we can go to the next slide, this slide shows the proposed text. You will note that the requirement for the self-assessment process remains, but the board is simplifying the language, and because of the proposed restructuring of the regulations, The requirement as proposed would now exist in two separate sections of the regulation text. Next slide, please. One final example, this slide shows the current and proposed text related to the temperature requirement for compounding areas. Next slide. Sorry, there's a bug. Okay. In the interest of time, I cannot review every example, but this slide illustrates some of the additional current requirements where they will be relocated under the new proposed text. Next slide. So this slide illustrates examples of current requirements that are proposed to be removed as the requirements are now adequately covered in the USP compounding chapters. And I'll give you just a moment. Next slide, please. In addition, in areas, the proposed text seeks to provide additional flexibility from the current requirements. This slide demonstrates some of those areas. Next slide. The staff recommended modified text reflects significant changes from the original modified text, in large part based on comments received during the 45-day comment period and the regulation hearing. This slide illustrates a recommendation to remove a proposed requirement in response to public comment related to evaluating trends in air and surface sampling. Next slide, please. This slide illustrates additional recommended changes to the proposed text, again, in response to public comment and consideration of those comments by the board. Next slide, please. I have only highlighted some of the changes, but I feel it necessary to note that a summary of all of the recommended changes is available on our website. To gain a full understanding of the comments received and recommended actions, please review the public information available on the board's website. Next slide, please. I also want to note that while USP has made significant changes to compounding requirements, the USP national standards address compounding that occurs in all practice settings, not just pharmacies. Further, USP in some areas references compliance with state regulations. This slide highlights some of the areas in USP that require further clarification by the board in its regulation to clarify the applicability of the standards to a pharmacy setting or where USP has deferred in its standard to a requirement in state law. If we could go to the next slide, please. So with your continued patience, and attention, I believe it may be helpful to provide some education on activities performed by the FDA and some public documents that are available. Next slide. So I do apologize because my some of these slides are going to appear pretty clunky. It's only because I'm trying to demonstrate that this information is publicly available and the source of the information. Next slide, please. So this is a screen grab from the FDA, which highlights several of the ways in which the FDA collaborates with states, including sharing information about compounders who engage in poor practices that could place patients at risk. I will avoid reading the entire slide, but I will pause for just a moment. Next slide, please. The FDA publishes on its website questions and answers related to compounding. Next slide, please. Including some examples, they ask if the FDA approves compounded drugs and information about the risks associated with compounded drugs. And I'll give just another moment to read. Thank you. Next slide. The FDA also includes information about the quality standards that apply to compounding, including, as indicated in this slide, the requirement for drugs compounded by licensed pharmacists to be performed in accordance with the conditions of Section 503A of the Federal Food, Drug, and Cosmetic Act, which Corinne has previously covered. You will note that the FDA specifically notes that regardless of where compounding occurs, other federal laws apply, including provisions related to insanitary conditions. The FDA includes that compounding drugs under insanitary conditions can put patients at risk and lead to widespread patient harm. Next slide, please. The FDA at times releases compounding alerts that may be site-specific or an issue-specific. Next slide, please. I previously displayed this slide, but I believe it's important to show through some screen grabs some of the important information shared by the FDA through its investigation into an issue that demonstrates that a specific issue can highlight a broader concern. I would ask that you please make note of the date of the release of this, which is June 7th, 2019. Next slide, please. The FDA did a nice job of providing an analysis of the investigation and its findings, highlighting that samples tested by the FDA were found to contain excessive bacterial endotoxins, with some results as high as 5 times the appropriate limit. This analysis also includes symptoms associated with exposure to inappropriate endotoxin levels, ranging from fever and chills to shock and death. Next slide, please. The FDA also provided conclusions as part of its alert. As noted, FDA included that L-glutathione powder the pharmacies received was labeled with caution dietary supplement and should have not been used to compound sterile injectable drugs. The FDA further stated that ingredients not intended for use in compounding sterile injectable drugs can be harmful when administered to patients because they may contain impurities and contaminants, including endotoxins. Next slide, please. FDA has issued other compounding alerts as well, including the one displayed on this slide. Next slide, please. As well as information, the FDA investigated 2 serious adverse events associated with a specific pharmacy that compounded curcumin emulsion product for injection. You will note that a patient died, and the cause of death identified by the local authorities was an adverse reaction to the infused curcumin solution. This incident occurred in California. Next slide, please. In addition to alerts, the FDA also issues warning letters. This is an example. Next slide, please. The FDA also publicly posts its observations from inspections. The FDA notes that these observations do not represent a final agency determination of compliance and sets forth how an entity can further engage with the FDA on inspectional observations. As indicated in this slide, as part of this inspection, which occurred after the FDA warning issued in June of 2019 related to quality of ingredients, the use of non-pharmaceutical grade component in the formulation of a drug product. In this instance, it was methylcobalamin. Next slide, please. As another example, this slide shows observations made during another inspection, again involving the use of non-pharmaceutical grade component in the formulations of a drug product. As noted, the pharmacy was using non-dietary grade drug substances in sterile injectable products. Next slide, please. Regrettably, this practice continues. In fact, just a week ago, the FDA released information again reminding compounders to only produce sterile drugs using components that are suitable for compounded drugs intended to be sterile. This information, released by the FDA, reveals that the FDA has received adverse events reports with patients experiencing severe chills, shaking, vomiting, and fatigue, with some requiring medical treatment. FDA notes that these reactions are consistent with excessive levels of endotoxins. Next slide, please. FDA MedWatch also issued an alert, which is displayed on this slide. You will note that this alert also references the previously released information wherein the FDA has highlighted concerns with using dietary grade to compound sterile injectable products. Next slide. This is a complex area. Compounders need to remain apprised of federal laws, national standards, as well as information released by the FDA. The FDA interim bulks guidance makes clear, for example, that the FDA does not consider USP monographs for dietary supplements to be applicable USP or NF monographs within the meaning of Section 503A. Next slide, please. Further, this guidance details out conditions under which the FDA will consider using enforcement discretion. Please note, as stated, there are conditions under which the FDA will consider using enforcement discretion. This screen grab on the slide references some of those conditions. I am noting this because I think this may be an area of some confusion. The FDA has established guardrails that some may not be aware of. Again, this is a very complex area that requires extra due diligence because of the real and potential harm to patients. Next slide, please. I referenced earlier an FDA alert that referenced compounding in insanitary conditions. The FDA has released an interim guidance that describes insanitary conditions. If we can go to the next slide, please. I'm not going to read this slide, but note that the guidance, again, is important for pharmacies and pharmacists engaging in compounding to be aware of when performing such practice. I'm going to just take a moment to, I'm not going to read the slide, but pause for just a moment so you have an opportunity to read one of the bullets that provides an example of an insanitary condition. Thank you. Next slide, please. Again, apologizing for my screen grabs here. The FDA has released information for compounders, emphasizing the need for compounders to know their bulks and excipient suppliers. Next slide. This is part of the screen grab. This information highlights some important issues and steps to be taken by compounders, including knowing if the supplier is testing the components to ensure it is of appropriate quality for use in drugs, noting quality of bulk substances and excipients can affect the quality of compounded drugs. Next slide, please. Further information includes that compounders are meeting the conditions regarding bulk substances, which the FDA details here. Next slide, please. The FDA also provides actions for repackagers, actions that they should take, including clearly identifying the original API manufacturer to customers who use them to make finished drugs, and to ask compounders how they intend to use the ingredient to ensure the ingredient is appropriate for use in a drug. Next slide, please. The FDA has also provided examples of quality issues with bulk drug substances and excipients. Next slide, please. So I just reviewed a lot of information about the FDA and its actions. This slide shows how the board has addressed this issue in the context of a case-specific adjudication. You recall from the previous slides that the FDA notes the importance of understanding the quality of the ingredients and transparency. This shows an example of a compounder using an ingredient without this information. Just a quick note, this is public information, but I did black out the name of the pharmacy. Next slide. In the hopes that it's helpful, I wanted to also review the perspective from some other agencies. So some commenters have suggested that the board is the only state evaluating bulk substances. I have provided examples of the FDA performing such evaluation. They are not alone. This slide is a screen grab from the NABP blueprint inspection that demonstrates that NABP is evaluating a pharmacy's ingredients in compliance with the USP requirements, including assessing APIs and other components. Give you just a moment to read. Next slide, please. Kentucky has issued warning letters, including the one displayed in part on this slide. Next slide, please. So this is a screen grab of Kentucky's compounding regulations. You'll notice that unlike the board's proposed regulations, which would permit the use of Category 1 substances in compounding, Kentucky's regulation specifically establishes in its standards the same requirements as those established in federal law related to components used in compounding. Next slide, please. Kansas is in the process of updating its compounding regulations as well. Like California, licensees in Kansas must comply with state and federal law. Kansas is providing clarity to its licensees, similar to California, through a rulemaking to update its regulations, although their approach is a bit different. As you can see from this slide, Kansas is proposing to clarify that, with one exception, all of the should provisions in USP will be replaced with shall under Kansas law. In the California proposed regulations, the proposed text does not establish that all shoulds shall be shalls. Next slide, please. Moving to another state's approach, Massachusetts is also in the process of updating its compounding regulations. Over the next several slides, I will show screen grabs from public information on the Massachusetts website regarding its proposed regulations. As shown on this slide, the compounding regulations cover a variety of areas similar to the approach in California. Next slide, please. In Massachusetts, as in California, a pharmacy license that performs sterile compounding shall comply with all state and federal laws and regulations. The law further explicitly states that pharmacists must comply with all chapters of the most current USP. Next slide. This screen grab shows the approach in Massachusetts relating to temperatures. Next slide. This screen grab illustrates the proposed requirements for environmental monitoring and action levels. Next slide. And this is an example where we see the proposed training and qualification requirements in Massachusetts. Next slide, please. Transitioning now to some additional examples of patient harm. Again, the purpose of these slides is to show the significant patient safety risks associated with improper or unsafe compounding activities and the importance of establishing compounding standards that assure patient safety. Next slide, please. I've again blocked out the name of the facility, as my intent is not about that, but to demonstrate that what we are talking about are not theoretical issues, rather actual examples of harm. Next slide, please. This slide shows actually the efforts undertaken by the board and the FDA to address issues related to compounding and dispensing sterile injectable drugs with dietary grade and non-compendial substances. You will note the time frame is well after the FDA alerts. It also details reports received of adverse drug events. Next slide, please. Patient safety concerns are not limited to the US. You will note that this alert was issued in 2023. Next slide, please. Regrettably, in August of this year, children were harmed by compounded products. Next slide, please. This is another example of a pediatric patient that died after ingestion of a compounded product. Next slide, please. The type and level of harm varies. As you can see from this slide, harm can include vision loss. Next slide, please. The Pew Charitable Trust conducted research in this area and in 2020 published information on patient harm caused by compounding. This screen grab is only a portion of the incidents of harm that were identified. Next slide, please. So, having provided information, I thought it may be helpful to review some potential action items for the board. As indicated on this slide, the board can do nothing with the current noticed proposed regulations. In this instance, the regulation will naturally expire after 1 year. The board could choose to withdraw the current rulemaking. In both of these instances, the board's current regulations will remain in place. At the staff level, I will say I do not believe this is appropriate. It creates continued confusion on the requirements. Further, I believe it could place the board at odds with the requirements in Business and Professions Code Section 4127, which specifically requires the board to review any formal revisions to USP 797 not later than 90 days after the revisions become official to determine whether amendments are necessary for the regulations adopted by the board. I believe the public record establishes that amendments to the board's current regulations are necessary. Next slide, please. So returning back to the board's statutory mandate. Medications need to be made in an appropriate and safe manner. Chemotherapy and radioactive drugs are vital medications. California should not be less safe. From public comment, it appears clear that some stakeholders don't want the board to pursue the proposed regulations, and some are seeking to lower the safety standards than what the board currently has in place. Patient safety must come first. While many in the public comments received are focused in a specific area, the board needs to focus on the regulations in its entirety, including for the pediatric population, patients fighting cancer. The staff recommended text incorporate many of the changes requested from commenters. It is important to note that the board cannot adopt a lesser standard than federal law and national standards. We can, however, help to facilitate operationalizing these requirements. It's for this reason, based on all of the information presented today in the public rulemaking, in the public meetings, and on the board's website, that staff recommend option 3. As noted on this slide and discussed previously, such action does not mean that the staff recommended text becomes the board's regulation. This action, however, will allow the board to reopen the formal rulemaking process, allowing interested parties to provide comments on the proposed regulation text and require the board to subsequently consider each of the comments submitted. Should the board agree with the staff recommendation, provided on this slide is a possible motion. You will note that as drafted on this slide, there are a few areas for the board to insert information. As required by law, comments received during the next comment period will be considered by the board at a future meeting. Thank you for your time.
Thank you, Anne. Thanks for the presentation. Members, I think that this is probably a good time to take a quick break. So we'll come back at 11 a.m. 11 a.m. All right, we're gonna get started. Hope everyone's, oh, you know what? I think we're missing a member. We're just gonna wait a little bit for Jesse's return. So we'll get started soon, everyone. Welcome back. Oh, there's Jesse. Take a roll call with Renee. No, it's not. Is it?
I don't think it's. Hey, Debbie, could you just make sure the microphones are unmuted? Oh, thank you. Thank you. No, we're good now.
Can you try, Renee?
Present.
Oh, there you go. Okay. That's better. That's nice. Thunderous. Jeff?
Present.
Thank you, Jeff. KK? Thank you, KKJ.
Present.
Thank you, Jay. Sachinder?
Present.
Thank you, Maria.
Here.
Thank you, Nicole.
Present.
Thank you, Jason.
Here.
Thank you. And Jesse.
Here.
Thank you, Jesse. And I'm here. Quorum has been established. Back to agenda item 17. Again, thank you so much, Corinne and Anne. It was a great presentation. I think that answers a lot of questions, and I'm really hopeful that this is going to help all of us in today's discussion. Any questions for Anne and Corinne before we get started on the discussion? Opening up, or anyone else for the matter?
I will just, I would like to thank you both again. Oh, where did you go? Oh, you're over there now. This was just such a clear presentation from both of you, getting an understanding as a non-compounding pharmacist. You know, a lot of this information was overwhelming, even as a pharmacist. So I can only imagine as a public member how much more overwhelming it is. But this really helped to streamline my understanding. And really just getting the resources to fully understand, you know, the legal side from the federal level as well. So thank you.
Thank you. Members, any comments, questions?
This is Renee. I just want to say thank you. I did tell Corinne thank you. It is very complex material, and I thought that was presented very methodically and very helpful. So I think that was really great. And then Anne, thank you. I think all those cases are good to review.
Thank you. Maria? Or do you want to say something? Yeah. Or just presentation? Yeah.
Just the presentation.
Yeah.
And then you're going to go.
Yep.
ask questions.
Yeah.
I just want to say not only I won't repeat what was said earlier. I agree, but I think the fact that there was direct screen grabs and to say where the information came from, that was very helpful.
Thank you, Satinder. Any other comments?
I have one. I had a question regarding some of the public comment that occurred regarding a doctor or a dermatologist buffering lidocaine for the comfort of their patient. We didn't really talk about that. Could you clarify that? Are those doctors still able to do that according to the new regulation?
So I can't speak on behalf of the Medical Board of California, who is their regulator. We don't regulate that practice setting. We don't regulate those individuals. It's my understanding that the medical board may have released information to people that requested clarification.
Okay, but because we don't usually respond to those public comments, we couldn't have clarified that with him, because I still had that question. It sounded like that was obviously being done to protect the patient or make it more comfortable for them to do their procedures. And we couldn't just say, oh, this is the wrong board.
Yeah, so we have requested something from the medical board to include in the rulemaking record as well. We just have not received it yet.
Okay.
Okay, any other member comments on the presentations or questions for Corinne and Anne? All right.
Is this the full discussion of this issue, or are we just talking about the presentations right now?
Oh, just presentation. Yeah.
Okay, got it. Thank you.
Okay, and now I think Maria.
I defer to Renee.
Okay, Renee, do you have some comments?
Sorry. About the presentation?
No, just in general. We're starting the discussion, moving forward.
Okay. Yeah, okay. Yeah, I mean, I can you hear me? Okay, just here. Yeah, I did want to say a few things. So as the board's compounding expert, you know, haven't said as much, but I just want to make you aware that here I am. And also, you know, just some of my background. So I've worked at Lucille Packard Children's Hospital, Stanford for over 26 years. And I have specialized in sterile compounding. I'm currently the sterile products manager. I've earned several certificates in sterile compounding along the way, and I'm currently board certified in sterile compounding. In my role, I'm also the designated person for USP 795, 797, and 800. I'm responsible for all aspects of sterile compounding for the children and the neonates in our hospital. Care for these pediatric patients relies heavily on compounded sterile preparations to meet their complex needs, including chemotherapy and parenteral nutrition. We compound over 1,000 sterile products daily. Essential for ensuring safe and effective sterile products for compounding compliance requirements, which are implemented, include FDA guidances, USP documents, California regulations, and as a hospital, CDPH, CMS, and accreditation agencies. I've spent my career in service to this goal of quality care. And then, I just have to say, compromise on the standards is just not an option, in my opinion. It's too risky. I do want to be open and express my concern that some of the provisions that have been asked for, what was discussed somewhat, are extremely risky to patients. So while I understand that patients are looking for flexibility to secure compounded preparations that are not FDA approved, I do believe that the board needs to move cautiously in this area, especially where the board is helping to create a pathway to compound bulk substances, actually beyond those that are allowed by Section 503A from the FDA. The testing provisions that are included and the SOP provisions included in the staff recommended text, while they're not an absolute guarantee of safety, they include requirements to address some of the risks that have been identified in the FDA compounding alerts, which were in the presentation, which include testing for impurities and endotoxins. We cannot lose sight of the board's public protection mandate. And I mean, I've considered, a lot of the comments here, and I'm just very concerned that some of the changes that are sought would undermine patient safety, especially for the most vulnerable patients, such as pediatrics, oncology, geriatric, and those with debilitating chronic illnesses. So I do just caution. Those are my comments about that.
Thank you. Thank you, Renee. Maria?
Thank you. I just wanted to give a few comments, and because I know this is going to be a lot of discussion, I actually wrote some things down to make sure that my comments are concise, so I don't ramble. So I appreciate you letting me speak. I wanted to thank Corinne and Anne for the presentation provided. I note that the information shared is consistent with the public discussions that have occurred over several years throughout the regulation development process. And I understand that many of our board members were not around when we went through all the background material. So repeating the background material again is very helpful, and actually is a lot more concise than the original presentations that were hours long. We started this process with several interactive committee meetings with stakeholders, and we as a group, that is the board as a committee and stakeholders, developed the initial proposed regulations. We had meetings in various locations to assure everyone had the opportunity for input in the development. I truly appreciate the ongoing input from stakeholders, as noted in the comments that we received during the 45-day comment period and hearing. The voluminous, and I can't understate that enough, the voluminous record shows each and every written comment and verbal comment received during the hearing period, the response, they're all responded, and the changes that resulted from the many comments. And so that's a testimony to the public comment does make changes. I wanted to let you know that I do understand the work to implement USP changes in board regulations, but I also know that many of you have already implemented some of these functions as USP standards became effective on November 1st, 2023, and is also regulated by other organizations such as the Joint Commission or CDPH. In my previous job, I have written many SOPs, created competency programs, and built compounding rooms with an eye always to where the USP standards are leading us. Some of you know in the past that I served as co-chair for several years on the California Hospitals Association and CSHP's task force on sterile compounding. We developed tools to assist hospitals and health systems on implementing the changing USP standards. These grids still exist on the CSHP website, although it's now out of date. I think they are waiting for us as a board to update our regulations before they update those grids that were tools. I highlight this to demonstrate that I understand the operational challenges that many fear. I'm confident that all of the provisions of the board's proposed regulations can be implemented if you're not already doing so. I encourage individuals to read the full rulemaking file and related documents. I realize this is a significant amount of information. Many are still surprised, and Anne mentioned it, that many of the proposed regulations are from existing regulations that are being reordered into the USP format. There are, and I hope that many of you have read the existing regulations, there are currently 45 pages of existing regulations regarding compounding. Those are all being proposed to be repealed and rewritten into the new numbered sections. I say this to remind you that many of the provisions that we're talking about during compounding discussions are not new. So here's I think something that I think is a result of public comment that I wanted to share, and it's regarding flavoring. We all agree that USP defines adding flavoring as compounding. We are pursuing legislative action to give some relief to pharmacists who can offer this important patient care service. This would allow the addition of flavoring without contacting the prescriber. This is only the first step. That's important to note. I hear from many that there is a need for regulatory relief also. I hear you, we hear you, and I believe that this can happen. I'm open to regulatory language to be added to 1735, which is non-sterile compounding. That would provide relief and still with the direction and safety required. I invite interested parties to submit proposed language during the next formal comment period. This can be done in an open and organized manner during the next formal comment period if the board approves to move forward in the regulatory process. We need to open another formal comment period to have productive discussions and change the proposed regulations with the input of all interested parties. One more point to add. Adding language to proposed regulations as a result of licensee concerns is not new. When licensees asked for more direction on what we have to do to provide more information on, let me say this better because it's important. When licensees ask for more direction, we do have the opportunity to add more detailed information in the regulations. This was the birth of the language surrounding Category 1 bulk substances in sterile compounding. We were asked for more information and for direction by licensees. As a result, you can see where that discussion has led us, but that was the intent. When licensees ask for more direction and information, we hear you, and if we can, we will add additional regulatory language to make it more clear. So I am open to adding language to make flavoring, adding relief to flavoring requirements, but that can be done and should be done during a formal comment period. Thank you.
Thank you, Maria. Really appreciate your insight into this matter and all your work for the last 2 years, well, like 5 years, but and to Renee and all the staff. So for me, the presentations reaffirmed my belief that the board's approach offered in the staff recommended modified text appears appropriate to allow for initiation of another 15-day comment period at least. I believe that the information shared in the presentation aligns with the federal law and actions and meets the board's consumer protection mandate. I appreciate the reminder that the regulations are necessary for all California patients. Having said all of that, I agree with the staff recommended offered in the final slide of Anne's presentation. I believe we should extend the comment period for 30 days. I also believe we should allow individuals to comment on all of the proposed regulation text, not just the staff recommended text. I think this is a very important caveat to this. I believe this is an appropriate approach which allows the board to continue its rulemaking activities, provide stakeholders with an opportunity to formally engage in the process, including providing comments on the text that was considered. So with that, I am happy to make a motion today. I know we have to read it, so if we can put that slide up, I'm more than happy to try to get that motion read into the record. Do we not have it on the slide? Okay.
Geez, 1 second. Nope, that's not it. Ah, here we go.
There we
Apologies
go.
for that.
So I'm gonna read the slide. Accept the board staff recommended responses as included in the packet, including the updated supplemental responses to the initial comments from the 45-day comment period and regulation hearing as the responses of the board, and approve the recommended modified regulation text dated August 29th, 2024 for a 30-day comment period. And additionally, delegate to members Serpa and Barker the authority to review comments received to the modified text during the public comment period with staff to present recommended changes and responses at a future board meeting. I just want to make sure that that includes the provision where that we're going to consider the entirety of we're able to receive the entirety of the text for the next public comment period. I hope that makes sense.
Yes, I believe that the board has the discretion and the direction to those members that you are delegating authority to and staff to consider all comments that are received.
I just want to make sure that it's not like we don't want to say that it's outside of the text. Yeah. Okay. All right. With that, I'm seeking second.
I'll second.
Thanks, Renee. All right, here we go. We're ready for public comment in San Diego. But before that, I'm just going to take one more pause to allow members opportunity to say, and then we'll do that again after the comments.
Just a quick question.
Oh, go ahead.
Previously, there was a motion to adopt USP 797 instead of this. Can you go, somebody, the expert, kind of show me that path of what's the advantage of that or a disadvantage of that? Do you recall previously in another meeting, it was discussed, just saying, we'll
So-
follow USP 797.
Yeah, so I think that that was a comment from the public. And so requiring USP compliance is already required under federal law and state law. So I probably missed the mark, but I was trying to explain in my presentation where there are gaps in USP. And if we take such an approach, there will be gaps that create problems. Gaps will persist in the area of, I believe, the interim guidance related to bulk substances. There are areas of USP that defer to the states, and we won't have responses to those kinds of things as well. And that's why I was trying to show how some of the other states are addressing it, that through like the Kansas slides as well as through the Massachusetts slides.
Does that, yeah, okay. Nicole?
Yeah, thank you. This is an issue I've been having a very hard time with, but let me be transparent in saying I am not a compounding pharmacist, so outside of my area of expertise, but watching these presentations was very helpful. Thank you. But I think where I've gotten to in the end is that at least a subset of what the commenters are asking for is they're asking for access to medications for disease states. And at the end of the day, that's not within our purview as the board. We cannot give approval of drugs. That's just not what we do. And I still think that there should be work done to get people with these disease states, especially ones that don't have any treatments, access to drugs. But that's just not what our board can do today. And I understand what people are asking for, and I hope that they keep advocating for that. But I just want to point out to those people that that's just not something that we have the power to do on this board. And so I hope that that can still be achieved, but we just can't do it for them. And that's what I've come to understand through this process. and appreciate all the work that everyone has done on this and getting us all there, and particularly the work around finding a way to allow us to do drugs, compound drugs that are on the bulk substance list. I think that was very creative, and really appreciate that we got there. And yeah, just acknowledging what a hard situation this is, but that we aren't the ones who can give people what they're asking for.
Thank you, Nicole. Hey, who knows? Maybe FDA will take action.
I just wanted to clarify one thing because this is a really complicated subject and sometimes words are misinterpreted. And so I think one of the things that while we can't change what the FDA guidance is, what we did do is, as a result of requests from compounding pharmacies, is add specific language in our proposed regulations to give a pathway for pharmacies that want to compound with Category 1 bulk substances, how to do it without reading or without getting an attorney or reading all the information from the FDA and from USP and from the state board. It actually states specifically what SOPs you need to do, what tests you need to do to make it safe, to provide access. So it's not a guess. So if you want to provide access, this is the pathway to do it. And I applaud the board for taking that step because that's something that the FDA has not put down into an FAQ. They say you can do it if you do all the steps, but then good luck in finding all those steps. And so we attempted to put those steps specifically in the regulation to help people have a roadmap on how to do it and do it safely.
Thank you, Maria.
This is Renee. I just wanted to add to that the provisions added for the testing is for safety. So, there's the avenue for access, but it's also safety, because I don't think anybody here is advocating to give a drug that may have endotoxins, which is really terrible, endotoxins or contaminants as a byproduct of the manufacture of the actual drug. So I don't think anybody wants to do that, but these are complex steps. You have to have a USP subscription to all the thousands of documents, the 1 to 1,000 that are compendial and the ones over 1,000, and know where they're all at or which ones would apply. So a phrase that I heard at the FDA compounding conference in August was, regulations provide standardization. So somewhat off what Maria said, somebody would have to sit down and figure out what are all the USP tests I should do for this, Category 1 drug, right? And somebody may forget about impurities, and then somebody has to come along and, somebody could be injured or hurt. So by having, this list, it standardizes what needs to be done. And it's really, in the end, to ensure safety.
I guess just to clarify, because when Renee said added, it means we added to our regulations. They're not new or different. We are pulling from USP the required steps for safety. So those are still required even if they're not in the regulations, because USP and FDA require these steps for safety. We, quote unquote, added them to our regulations to provide information to licensees on how to do it so they don't have to go and search for them and make those determinations on their own. So they're not things that we're adding as a board. They're already there in FDA and USP. We just listed them for you to provide a pathway forward.
Thank you, Maria and Jesse.
I have a question for clarification, just from a process standpoint, for the non-sterile compounding, specifically with flavoring. So if we open this up for a comment period, is the idea that the staff will potentially accept the recommended comments and incorporate that, or is it the sort of thing where it has to come back to us again and then we reopen it for a comment period with the language?
Go ahead.
Oh, so as I understand the motion, we are going to be considering all comments that are received. So if If comments were received specific to flavoring and non-sterile compounding, that would be considered and then brought forward to the board as required by law for consideration of all the comments that were received at a future board meeting to then determine what the next step in the rulemaking process would be.
Okay.
And just to reiterate what I had said during my initial comments, I'm inviting comments about flavoring to provide relief for pharmacies within what we can do from federal law and USP. So you can't just say flavoring is not compounding or flavoring does not require these compounding steps. We need some help here, to be very specific on, what is and is not required when you do flavoring as some sort of relief. Similar to what we did with Category 1 bulk substances. We didn't say if it's approved or not approved. We said, if you do Category 1 bulk substances, these are the tests that are needed. These are the compounding that's needed. I'm looking for something, so I'm putting my little commercial out here. I'm hoping that you will provide us information on how to word this so that it's easily understood, is still following federal law and USP standards, within the purview of the legal authority of the board, and provides relief to pharmacists. That's a big ask. I need help.
Thanks, Maria. I think we'll take your commercial over any of the real commercial. So with that, we're going to go for public comment. But just a reminder. Oh, go ahead.
I have one more question, just like from a process standpoint. I know we've gone to public comments several times in this process. So I'm just trying to get an idea of if we even know where we are at this point. Are we hoping that this is like a final comment period for it, or do we think this will be ongoing?
I think it's probably too early to tell. We have to get that's the value of the public comment period, is it's going to help us gauge where we are in terms of it. So I think, at the last board meeting, we, called out the fact that we're probably going to need to schedule another board meeting, right? For this purpose. We may tag other things onto the agenda as is our process, but if we're doing the 30 days, right? That's not going to be, we're not going to have the responses back for the December board meeting. So we're probably going to be looking at doing a board meeting in January. At that time, Jesse, I may be able to answer your question. Apologize, I can't do it now. I think a lot of it's going to depend on the comments that we receive back and whether or not, we're close, or if we're going to have another 15-day comment period or whatever.
Okay. And then my last question is there a deadline to get this passed or to get this moving forward?
So I'm going to punt that to Noreen.
The Office of Administrative Law, or the Administrative Procedure Act, requires that the rulemaking be submitted to OAL a year after publication. I don't remember the date of the publication.
Okay.
So just to clarify, because I know, and I appreciate the motion and in favor of the motion because it allows the discussion to continue. Right now, we're kind of in the, trying to catch our tail discussions, and having another formal comment period will allow to formalize the discussion and get comments from the public that require feedback. And so that's why we cannot continue to just have discussions at the board meeting without it being formalized and opening a 30-day comment period. The 30-day comment period, I'll just make my little projection. I have my crystal ball here, which I'm sorry, Anne, and I'm not going to look at Noreen, but the 30-day comment period will result in additional changes. It's not, I know that. That means that we'll have another comment period after that. So the comment periods continue each and every time we make changes. That is a good thing because it means the discussion continues in a approach that is productive. The discussion here influences the board, but it's not productive to the regulations moving forward. And in the meantime, the licensed public are in this limbo because USP was enacted in November 1st, 2023. And our goal was to have regulations updated to be in line with USP around the same time. And you could see that it's been a lot longer than that. And so we do need to move forward. And so that's one of the problems I have. It's better for me to have something written down than to talk off the top of my head because I seem to always alliterate, and I apologize for that.
No, not at all, Maria. Don't apologize. Thank you. Okay, members, we'll have more time to talk about it. Just a reminder that as we go into the public comment, that we'll probably take a lunch break at 12:15, depending on the number of public comments. So I'm sorry, but there are just some labor laws that I have to adhere to. So, all right, with that, we're ready for public comment in San Diego first. So just come on up or however you all want to do.
And
Thanks.
when the green light is on, your microphone is live.
How about now? Hello, I'm Sam Martinez. I'm a licensed pharmacist from UC San Diego Health. Thank you for giving me the opportunity to speak today. I'd like to first thank the board for taking so much time and effort to go through these compounding regulations. I'd like to acknowledge that many comments have already been implemented, and I appreciate that. I've been part of many of the meetings, so I can appreciate the time and effort spent on going over these regulations. But I also feel it's necessary to get these correct because they could have wide consequences for licensed compounders. With that, I would like to specifically talk about section in Article 4.7 hazardous drugs, section 1737.5 facilities engineering controls. It states in section C, where a pass-through is installed in a CSEC, the doors must be gasketed, interlocked. And then it says a pass-through is not allowed between the hazardous buffer room into a unclassified space. And then in section D, it goes on to give details about what a pass-through would look like in those spaces. So it's just very confusing. Are you saying a pass-through is not allowed? Or are you saying if you have a pass-through, it needs to be interlocking? And then it goes on to talk about HEPA filter pass-throughs. So I feel like this is an important section that needs to be clarified. I've reached out to many experts on facilities engineering controls, people who design and build clean rooms for a living. They agree that there's no issue with a pass-through between a hazardous buffer room and unclassified space, as long as there's controlled via HVAC. If you want it would be my recommendation if you want to add hazardous
This is
waste
the moderator,
sampling.
10 seconds.
Maybe that would be a recommendation or a HEPA filter. But if we could get clarification on that section, that'd be appreciated. Thank you.
Thank you for the comment, Sam. Go ahead, Ann.
So I just want to say that I just want to make sure from a process standpoint that people understand that totally welcoming everybody's public comment. Just want to be very clear, but to engage in the formal, in the rulemaking process, please submit your comments during the comment period as well. Like I said, I'm not trying, please say your comments now here, but the written comments during the open comment period are going to be extremely valuable as the board moves forward with its rulemaking process. Thank you.
Thank you, Ann. Thanks for stealing what I was about to say. Oh, I feel very stolen. But I was just going to say that I think that's a good comment, Sam. Exactly. I mean, I'm hopeful that we're going to push this past this motion so that we'll be able to see all the things that we want to see in the comments so that we can understand the logic and anything and everything in the entirety of the regulation text. I'm really hoping to see your logic of why you feel this way so that we can try to understand and see what we can move forward. So really appreciate the comments though. Thanks, Ann. Alrighty, next comment.
Good morning. My name is Cameron Dimitri. I'm with Hims and Hers Health. I want to thank you all for the work that you're doing. It's really important and appreciate all the deliberation that you've taken. Hims and Hers is one of the nation's leading direct-to-consumer telehealth pharmacy companies. We'd like to directly address provision in section 1735.1 related to clinical determination. The language suggests that the board would require a pharmacist to assess and confirm the clinical significance of a prescription already deemed necessary by a licensed provider. This proposal represents a fundamental shift in medical practice. We appreciate the progress that's been made, but It would place pharmacists in a position to override or delay prescriptions written by licensed clinicians and require them to make clinical determinations on patients or patient records they may not have directly reviewed themselves. This creates several risks: risk to patient care, operational challenges, unclear problem resolution, potential risk to pharmacists, risk to patient care. Shifting clinical decision-making to include a pharmacist approval adds potentials for delays, jeopardizes timely access to essential medications, and undermines the treating clinician's expertise in patient care. Operational challenges: implementing such a process would introduce significant logistical hurdles across all pharmacy settings, retail, hospital, contract pharmacies, resulting in increasing staffing, training, operational, and legal burdens. It also remains clear what specific issue this requirement seeks to address and whether the proposed solution would actually inadvertently create more challenges, such as treatment delays and increased liability for pharmacists. And lastly, pharmacists could face heightened liability if they unintentionally deny or delay prescriptions that clinicians have determined to be appropriate for the patient. We ask the board to consider carefully the negative implications of this proposal.
This is the
for
moderator,
this
10
element of the
seconds.
proposal, and urge you to consider this in your next formal rulemaking process. Thank you.
Thank you for the comment.
Mark Johnston, CVS Health. First, I'd like to point out that most state boards of pharmacy have adopted USP and are working on exceptions to USP, not additions to USP. With that said, I do greatly appreciate many of the changes that the board has made in this draft compared to previous drafts and the visible process that you've created here. I'm really down to just two comments. One is that the board's direction, President O specifically, was to have the hazardous rules only pertain to compounding and not handling. However, that's not what this version does. This version also includes other manipulations included in Table 1 of the chapter of anti-neoplastic HDs, which is not compounding. Specifically, in that list, activities that CVS retail pharmacies engage in are pouring a hazardous liquid from a stock bottle into a bottle that's labeled and dispensed, throwing away gloves that are used when counting and cleaning a tray. And for that, these rules would now require that we have to have documented and demonstrated competency training, which seems expensive, excessive, with little public safety protection for pouring from one bottle to another. The second thing is that in 1735-10, beyond use dates assigned with only a date shall expire at 11:59 p.m. on that date, meaning that there's no reason to document at the time of compounding the time of compounding. However, it is required in 1735.7 that you do document the time of compounding. If the time of compounding is absent,
This is the
you can
moderator,
still
10
issue a beyond
seconds.
use date. So I think the time of compounding should be not mandatory. If you want to document the time of compounding, then you have additional BUD allowances specific to
This is the
that
moderator, time is
but it
up.
shouldn't be mandated. Thank you.
Thank you for the comments, Mark.
Hello, my name is Patrick Yassini. I'm a medical doctor, and I'm double board certified, and I've been practicing for 25 years. I'm not here, and I have no interest in compounding pharmacies, nor the industry. I'm just here from the perspective of a physician that's taking care of patients, and I understand the whole rule is about protecting the public, and so we're in complete alignment here. But I wanted to point out a couple things that from the presentations. First of all, the FDA approval process costs lots and lots of money, and some of the things that we prescribe through the compounding pharmacies will never make a pharmacy or a pharmaceutical company a lot of money, so they're not going to invest all that time and effort to gathering the data the data that the FDA often relies upon to put on their lists or whatever. And having said that, even I serve also as a principal investigator. I've done over 100 clinical trials in my career, and many of the data that I created or helped create went for approval of many of these drugs. And I can tell you that even when used on label for appropriate uses, they're responsible for a lot of deaths. So although I acknowledge some compounds have caused some harm, we should also acknowledge that even FDA-approved drugs with lots and lots of data have traditionally caused over 100,000 deaths a year. Now, I also want to say that as a doctor, I like to have the entire spectrum of tools in my toolbox when treating my patients. And already in California, with the rules that are already in place, I have trouble accessing some of the things that I think are essential.
This is the moderator, 10 seconds.
Patients. And I can tell you my colleagues in other states have not as much trouble. And as much as I understand the need to protect the public, I just want to encourage you to make the barriers as attainable as possible, and perhaps even the
This is
same.
the moderator. Time is up.
Thank you for the comments. There public comments?
Good morning. Hello again, friends. I'm Jackie Jorgensen, the founder and executive director of the Volunteer Fire Foundation and a 9/11 survivor. I'm speaking as a patient. IV glutathione brought my extremely high levels of jet fuel and other petrochemicals back into normal range, and an advocate for the firefighters that we serve. We launch round 3 of our groundbreaking glutathione-centric firefighter detoxification program next month, and we'll be publishing our first 2 rounds of data in 2025. This morning's presentation hewed closely to the testimony that your staff delivered to multiple administrative law judges in various lawsuits filed against 503A pharmacists who dispensed methacobalamin and glutathione. But there's a reason that the judges sided with the pharmacists on this matter. When you have expert witnesses and time to examine these arguments, they fall apart. There was a lot of information that was disingenuous. We could talk about the endotoxin, the Let Go Infuserve incident. That was one isolated situation. It applied to no other pharmacists, and they were appropriately punished. The FDA, staff members who recommended against methacobalamin and glutathione, their own advisory committee disagreed, and the FDA had the choice to not add those items to the list, but they chose to because they ultimately agreed that these substances are safe. The FDA also doesn't want to interrupt patient access, but these firefighters cannot currently access nebulized glutathione. The 503Bs don't make it. The 503As won't make it because they've been sued, harassed, intimidated, defamed, and fined by this staff. That's the reality of the situation. I want to know why we're the only ones speaking out. I keep thinking someone's going to speak up and say, hey, good job. This is a long time coming. Thank you. You're protecting Californians. I've listened to over 10 hours of public comments at this point across 3 meetings and a public hearing. I
This is the
haven't heard
moderator,
one
10
of those
seconds.
people yet. That doesn't add up. Thank you.
Thank you for the comments.
It's really nice to meet you all in person. My name is Crystal Frost. You've heard me comment a bunch on WebEx. I'm going to try to squeeze everything into the 2 minutes. I'm here representing Stop the BOP, which is made up of nearly 8,000 petition signers, sick patients who depend on Category 1 compounds. And our main concern is, well, there's a few. The board is obstructing patient access to these legal compounds already before these regulations even exist. Number 2, you're misleading other board members into believing that these widely used treatments are dangerous by misrepresenting statements by the FDA, and I'll get to that in a second. And number 3, you're enforcing restrictive policies on these legal treatments prematurely without authority. Your lawyers' presentations were, in a word, misleading, providing intricately assembled anecdotal evidence to try to defend excessive regulations that you simply don't have evidence to support. Based on my research, and I'm sure others attending this meeting, every single example you provided of endotoxin poisoning was due to pharmacy cutting corners and not abiding by federal standards, which ensure and guarantee safety. By this logic, you're proposing treating every compounding pharmacist as a criminal simply because a few rare pharmacies are committing crimes. You're also attempting to mislead board members into thinking the updates to the proposal preserve access, which they actually don't. At best, your proposal will raise prices exponentially by requiring excessive testing requirements that aren't required for other far more dangerous drugs, inevitably pricing out vulnerable patients like myself. At worst, though, it ends access because you've already threatened and penalized pharmacies for producing these substances, and they're scared to continue at this point. Category 1 compounds are vital for patients dealing with chronic illnesses, neurological conditions, and other complex health issues, and they have an
10
incredible
seconds.
safety profile, with IV preparations having significantly fewer reported side effects than every single IV antibiotic, just to give one example. I realize I'm out of time. I hope you guys reconsider and just adopt USP 797. We just want you to align. Thank you guys so much.
Give it a comment.
President O, I'm sorry, could I interject for just 1 second?
Sure, go ahead.
I just wanted to, with all due respect to the public comments, I just wanted to make sure that the board understands that these category 1 substances we're talking about, specifically glutathione and methylcobalamin, the FDA has not made their final determination on those substances yet. They're still under evaluation. So yes, it's true. Their initial evaluation was these substances are not safe. We don't recommend they go on the 503A bulks list. The advisory committee voted, yes, they should go on, but FDA is not bound by what the advisory committee says.
Thank you, Corinne. As always, I wish life could be simple, but never is.
Likewise.
Thank you
Thank
for the comments. Go ahead.
Okay. I'm Dr. Sharon Wampler, did my PhD here at UCSD, and I'm the founder of the San Diego Lyme Alliance. I actually worked in biotech and pharma for 10 years, then ran 2 departments at UCSD. I think I have a unique perspective. I worked in R&D for drug development and did process development for scale-up of viral vector production for phase 1 human clinical studies. So this was actually a sterile infusion. So I was regulated by GLP, GMP, 21 CFR, et cetera. So I actually appreciate the presentation you did. I'm coming in kind of late to this. I've just learned about this, but I do appreciate that you're willing to extend for 30 days because, as you've said, it is an iterative process, and I think it's important to get it right. There is concern about, I understand and fully appreciate that safety is paramount because we were manufacturing things for injection into humans. So when I first learned of this, I thought perhaps it was a response to spa medicine and the proliferation of this, which I myself have issues with. So I would just encourage you to be, not to consider the situation and to be flexible and take in the public comment and continue an iterative process. So again, I have a flight early in the morning. I just learned about this recently, and I look forward to actually being able to read the full regulations and see the next steps. So thank you for protecting the safety of the public. But I do want to also comment the National Academy of Science. Yep, National Academy of Science Engineering in June 2023 convened with the FDA, CDC, and DOD for Lyme and tick-borne disease, and there is a request to Congress to create a new center for chronic infection-based chronic
This is
illness.
the moderator.
This is
Time
an
is up.
emerging process, and we need unique treatments. Thank you.
Thank you for the comments.
Good almost afternoon. My name is Carolyn Degnan, and I'm the COO of LymeDisease.org, which is a 503(1) national nonprofit organization. Many of our chronic Lyme disease patients are immune compromised and simultaneously develop other chronic complex diseases such as ME/CFS, MS, long COVID, reactivation of Epstein-Barr viruses, as well as other viruses and mold issues. Prior to joining LymeDisease.org, I was a practice manager for one of the largest complex chronic disease practices in Northern California. During my 8 years there, our practitioners treated over 10,000 new patients, many of whom required treatment with compounded B12, methylcobalamin, and glutathione, just to be able to get through their normal days. Glutathione is a major binder used by many practitioners treating ME/CFS, and for our frontline firefighters, patients who also have Lyme disease and unfortunately are exposed to toxins when they're fighting fires. My original background before becoming involved with Lyme was a litigation consulting researcher, and I spent my time working with many of the top 10 companies in Silicon Valley. In researching this issue, I have not found another state pharmacy board that has enacted these draconian, in my opinion, practices. You did mention Kentucky, Kansas, and Massachusetts. It's on their to-do list, but it's not been passed. Patient access is a real issue here. The FDA has stated that patient care should not be disrupted while the Category 1 list is
10
being
seconds.
reviewed. LymeDisease.org is asking the board to vote to continue to allow Category 1 compounds, including B12, glutathione, and other categories.
This is the moderator. Time is up.
Thank you. Thank you for your consideration.
Thank you for the comments.
This is the moderator. Can I say something for the people on WebEx before we go to our next person, San Diego?
Sure.
Okay, I just want to let everyone know on WebEx, I am keeping track of people who have their hand raised or have mentioned in the Q&A. Just let you know, I do see that you have requested comment, and when we get to WebEx, we will get to your comments. So please be patient. Thank you.
Thank you, Sarah. Okay, go ahead.
Is this on? Yeah. All right. Hi, I'm Bram Veerman, a husband of someone living with a debilitating chronic neurological disease. Thank you for the opportunity to voice my concerns. To add to what Crystal Frost said, FDA stated patient care should not be disrupted while the Category 1 bulk substances are under review. Therefore, you guys are superseding the FDA. Experts, doctors, and patients have been relying on these compounds in question for a very long time, and it is crystal clear that they are safe and effective. We have amazing scientifically backed standards already, and these compounds are on the Category 1 because the FDA deemed these substances safe. The proposed text that was written with obfuscated writing has a very clear and scary intent, lacking scientific backing. The public is smart and took notice. Your board holds such great deal of power that should be used for the public good. And it's clear that most of you do care and want to protect the public, but some of you seem to not. You have been caught getting your facts wrong on numerous occasions and not once offered an apology to the patients you are supposed to protect. Why? You owe us a sound explanation for why California must be significantly more restrictive than all 49 other states. Please do the right thing. Send it back to committee and adopt USP 797. Please align with federal standards. Thank you so much.
Thank you for the comments.
Thank you so much for giving me an opportunity. I don't have anything prepared. I'm a sterile compounder in Los Angeles, a sheriff PIC of Rancho Park Pharmacy. Thank you so much again for giving me an opportunity to speak. I'm just listening to this, and my pharmacy has never used any bulk drug substances on Category 1 because we want to be very much compliant with our state board requirement and also FDA. Just hearing all this patient need thing, it's just why can't we, our board can plan to collaborate with the third-party analytical labs to get some more information from the experts that are running these labs to require certain testing on the API on a couple of these items that are so much in demand. And then that becomes a requirement, let's say for 503As, to perform those testing on the API, just like they are required to do end product testing, such as USB 85 and 71 on the end product. Maybe that would at least make some assurance for us to make sure that the actual source is, even though it doesn't have a USP drug monograph, all the pharmacies are complying with these tests. Thank you so much.
Thank you for the comments. Okay, do we have any other in-person comments in San Diego? Please come on up or raise your, come on, okay.
Hello, thank you for this meeting and for hearing our comments. I am Dr. Svetlana Voloshin, a naturopathic doctor in the area, commonly using compounded medications. And I wanted to comment on a few things in the presentations. Some of the reasons that, well, the reason we don't have USP drug monographs for methylcobalamin and glutathione is that these categories were recently changed from dietary supplements to drugs. And so I don't believe that that should be the reason that these are excluded, as these compounds are vital for patients struggling with complex chronic conditions, including long COVID, tick-borne illnesses, and so much more. And they usually don't have a lot of options, and they depend on these medications in order to get through their days. These medications have a long record of safety and effectiveness with hundreds of studies available. They are much safer than many approved, much more dangerous drugs. And many of the examples in the presentations were one-off examples of individuals or pharmacies that did not follow protocol. This does not mean that they are unsafe when used correctly. Fever and chills are also often a detox reaction. It does not necessarily mean that there was an endotoxin contamination. Of course, this does occur in compounding, but not likely during administration. So why limit these compounds? The focus should be on demanding cleaner environments and cracking down on those who do not follow current regulations, not on limiting helpful compounds by making it nearly impossible to compound, driving up costs and reducing access. Please adopt the USP 797 or at least extend for further comment. Thank you so much.
Thank you for the comments. Any other in-person in San Diego? All right, we are ready for WebEx. Sarah.
All right, one moment, and I do have some instructions that I'm going to read before we get to the comment. So just a reminder, if you would like to make a public comment on this agenda item, please use the raise hand icon on your WebEx screen. If you're an audio-only participant, you may press *3 on your device to raise your hand. Additionally, you may also use the question and answer feature to indicate that you would like to make a public comment. I do please ask that if you have your hands raised, don't also use the Q&A. And then as a reminder, once you are unmuted, please give WebEx a couple seconds for your audio to connect. That way your beginning statements are not cut off. And we do have a lot of commenters today, so I please ask that everyone be patient while we get through everyone. And we'll go ahead and get started. So first I have Courtney Sullivan. Courtney, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Members of the board, my name is Courtney Sullivan, and I'm an attorney at Bozeman Snow in Scottsdale, Arizona. Bozeman Snow represents sterile compounding permit holders, licensees, and medical providers throughout California. Our clients are rightfully concerned about the implications of these proposed regulations on patient access to care in California. If this board approves these changes as written, people in the state of California will lose access to therapies that they and their medical providers believe are best for them. Passage of these regulations will further the already existing socioeconomic divide among Californians. The citizens of California that have the means will seek their necessary medical care in neighboring states and countries. Those who lack the means to obtain care outside of California will go without necessary medical care and suffer the physical consequences for their lack of appropriate medical treatment. Citizens of the state of California should have open and fair access to necessary medical care in consultation with their doctors. On behalf of our clients and their patients, we respectfully request this board decline to implement the proposed changes. Thank you.
Thank you for the comments.
All right, this is the moderator. Next, I have Council Member Marjorie Morgenstern. And Marjorie, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Stern, and I'm a councilwoman from Sonoma County. In Sonoma County, we have various and numerous firefighters that use glutathione when they've been exposed to toxins to detox. This is an important treatment that I don't think should be taken away from our firefighters. They're incredibly important to our community. I also am a Lyme patient, and I have really benefited from treatment with glutathione and B12 injections. I think the board is being excessive. Please do not pursue the proposed excessive regulations. Adopt USP 797 so Lyme patients don't have to move out of state to get the treatment that they need. Thank you.
Thank you for the comments. Just a reminder, we're probably going to go to lunch around 12:30. To anyone in line, please stay in line. We'll probably take about 45-minute lunch. A second reminder, again, this is the motion is just to comment period, open for 30-day comment period. Really would appreciate in writing if you could just help us understand why you feel with our text, not just say so, but to help us understand your perspective, because that really would help us as well. And this is, again, not a final, this is a comment period to the next step. So I just want to make sure that's out there. Thank you. Continue, Sarah, please.
All right, this is the moderator. Next, I have Danielle. And Danielle, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
My name is Danielle Castrens, and I'm here to speak on behalf of my dear friend who is suffering from a chronic illness. She endured neurotoxicity from an FDA-approved antibiotic, poisoning from FDA-approved MRI contrast, and permanent disability from a failed lumbar puncture and blood patch procedure. Compound medications like glutathione have helped her regain some quality of life. I've seen her struggle through this chronic illness for years, and I will not stand for you taking the treatments that are helping her. Your proposed regulations would strip away these essential treatments. What you are doing is cruel, and to be blunt, you don't have patients' interests in mind. You are taking these treatments away from people who need it the most: firefighters, chronic illnesses, those with long COVID. You are willing to increase hospitalization, worsening health conditions, and higher healthcare costs for what? You know that these treatments help people, and yet you are trying to take it away without scientific evidence to prove that these medications are causing harm. I urge you to do the right thing. Don't abuse your power. Think of your loved ones and what you would do for them. Would you ensure that they have access to the treatments that help them? Work for the people and not for the corporate interests, whatever those may be. Thank you.
Thank you for the comments. Just again, for the record, we're not trying to take any treatments away. Thank you for the comments.
All right, this is the moderator. Next, we have Drea. Andrea, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
My name is Drea, and I wish to share the significant benefits I've personally experienced with glutathione. which is a vital compounded medication that has been integral to my wellness and the wellness of countless others, including firefighters and first responders. As someone who receives glutathione treatment, I can attest to the profound impact it's had on my health and the well-being through my recent health journey. These treatments have made an incredible difference in my road to healing, supporting my cellular health, detoxification, and improving my immune function in ways that conventional treatments could not alone help. For many individuals, including those with chronic health conditions, access to glutathione and other compounded treatments is not just beneficial, but it's essential. These therapies bridge the crucial gap, empowering patients to achieve and maintain better overall health outcomes. It is so deeply concerning that the proposed regulations stand in contradiction to the FDA's findings and determinations regarding the safety and efficacy of these compounded ingredients. The FDA's decision to maintain the availability of the compounded B12 and glutathione at the federal level underscores their importance and proven safety profile. Limiting access at the state level would undermine the progress and negatively impact both practitioners and patients. I understand that there are some bad actors out there in the world, but it's the exception, not the norm. It's also exactly why we have safety guardrails in place to identify issues and resolve them. Throwing the baby out with the bathwater by taking away access is not the right way to go about this. I urge the board to recognize the vital role of these compounds play in supporting comprehensive patient-centered care. Please accept the USP standards instead of the proposed regulations, otherwise hold a separate meeting on this topic where a more open conversation can happen. This call to action is more important now than ever to ensure that our state remains aligned with federal regulations protecting access to these essential treatments. Thank you for considering this perspective and for your commitment to safeguarding the health and well-being of California residents.
Thank you for the comments.
All right, this is the moderator. Next, I had Dr. Orjan Masrer. And Dr. Orjan, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Hi there. Can anybody hear me?
Yes, we can hear you.
Oh, hi there. My name is Orjan Masrer. I'm a family medicine, internal medicine physician here in West Hills. I just heard about, first of all, thank you for taking my call. And this is a very important topic. I know I don't have too much time, but I can tell you and the panel here, my experience with glutathione, NAD, and vitamin B12. I've been using these products for maybe 10 years now. When people at some point didn't even know what glutathione is, some people don't even know what it is today. I have used this, I'll call it a medicine, even though I know technically it's not, but I have used this for, I can't even tell you what variety of patients I've seen that I have treated with this. Yeah, from Parkinson's to dementia, hypertension, hyperlipidemia. I've treated people with insomnia, chronic pain. As you guys all know, this is a phenomenal anti-inflammatory antioxidant, and to take such a thing away would be a disservice to these patients. Not to say that we don't give them FDA-approved medication, which we do, but I need to have everything at my disposal to be able to treat these folks. I cannot quantify this. I have not kept track of how many people I've kept out of the emergency rooms and the hospitals, but I can tell you that maybe hundreds, and I've kept a lot of people off medication. We are here as doctors to do what's best for the patients, and I have seen throughout the years that
10 seconds.
This is one of those things. I don't even have time yet to talk about NAD and B12, but the glutathione was the biggest. So I hope you take this into consideration and please allow it. Do not take this away from these people. And have.
All right, this is a
Thank you
moderator.
for the comment.
We're going to move on to our next individual. I have Amy Segoy. And Amy, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Amy Segui, and I work for the Petaluma Fire Department in Sonoma County. I appreciate the presentations today, but I want to add the FDA does permit the sterile compounding of glutathione under specific conditions. In 2022, the PCAC recommended adding glutathione to the 503A bulks list. As stated initially, the FDA expressed concerns about the contamination. However, ensuring the quality and purity of glutathione for sterile preparations is a core part of current USP standard chapter 797. So aligning with the USP standard would align you with the USP, FDA, and PCAC, which are the leaders in this space. I do condemn the one-sidedness which lack to highlight the years of safe use in California and the lives saved by the access to this medication. All medication has potential risk. Part of the beauty in being an American is that we have the freedom to weigh risk and make our own health decisions. Restricting access unless a commercially available equivalent is absent fails to recognize that many patients have unique health needs, which often necessitate specific formulations. The FDA and USP guidelines already allow for these unique cases under clinical supervision, while this proposal would limit these personalized care options. It might sound navigatable on paper, but who here hasn't insurance systems to be able to justify your needs? There are topping class drugs here. Thione is an antioxidant.
Hi, sorry, we cannot hear you well. Can you
I'm sorry, can you hear
try
me?
to make sure your microphone is fixed?
You're still a little quiet, Amy. Do you mind getting closer to your microphone?
Better now?
No, unfortunately.
I think the cable got unplugged or something because I hear it very faintly.
This is the
We can
moderator.
come back to you.
Okay, I'll put Amy on the back burner for now. That way we can kind of keep moving, and we'll come back and hopefully her microphone is fixed. So let's move on. And Amy, I'll keep your hand raised so I know to come back to you. Next, I have Kirsten Rose. And Kirsten, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted, Kirsten.
Can you hear me?
Yes.
Thank you. I'm urging your board to please accept the USP standard instead of the proposed regulations, or hold a separate meeting on the topic where a more open conversation can happen. My doctor prescribed nebulized liquid glutathione for the treatment of my acute mold exposure and COPD. I found it to be safe and effective, and I rely on this treatment, and not accepting USP standards would disrupt my healthcare and my recovery from chronic illness. Thank you.
Thank you for the comments.
All right, this is the moderator. Next, I have Dania Sarani. And Dania, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Can you hear me?
Yes, we can hear you.
Great. I'm Dania Cerrone. I'm a registered dietitian. I have a master's degree in food science and nutrition. I have pernicious anemia. I'm totally dependent on compounded methylcobalamin since 2018. I'm very high functioning. I work full time, but I cannot function without this. Today, I was disappointed by how one-sided the information presented was. There was no information included on the safety or efficacy of methylcobalamin, and I would ask you to look at peer-reviewed articles such as the JAMA investigation of the efficacy and safety of ultra-high dose methylcobalamin in early stage ALS, which was published May 9th of 2022. Already since January 1st of 2024, I've experienced many obstacles in getting this medication. This impact directly impacts my quality of life and what I'm able to do each day. I would ask that you please consider the obstacles you're creating for patients. all you really seem to have in mind are our best safety. Yeah, I really ask that you consider all of these comments. Thanks so much.
Thank you for the comments.
Can I interject for just a minute? If that's okay. I just wanted to share some language from USP, just in case it's helpful. USP 797 has a section on components, and I just wanted to read part of that, and whatever, just putting it out there, should it be helpful? It says when CSPs are used as components, and then it refers you to section 16, it says all APIs and other components used must be evaluated for suitability for use in sterile drug preparations. Components labeled with not for pharmaceutical use, not for injectable use, not for human use, or an equivalent statement must not be used to compound for these purposes. So I just wanted to share that language. I didn't cover USP in my presentation, so just wanted to share that, should that be helpful information.
Thank you, Anne.
Can I ask a clarifying question, or is that not appropriate?
Go ahead, Maria.
So the clarifying question is, so USP specifically says do not use, right? Is that what you're saying? But our board regulations are saying if you use, this is how to do it safely. Am I interpreting that correctly?
So I'll give it the answer, and this, I believe the words are what they are. What I would say is we are in the proposed regulation text, putting in some testing provisions where someone using their clinical judgment can assess the quality of that bulk substance, independent perhaps of how it is labeled.
Thank you, Anne. Thank you, Maria. Okay, Sarah, go ahead.
All right, this is the moderator. It looks like Amy Segui got her microphone fixed, so I will go ahead and request to unmute. Once again, Amy, you got 2 minutes to speak and a 10-second warning. Please click that unmute me button when the prompt appears on your device.
Again, my name is Amy. I work at a fire department here in Sonoma County. I'll just start again. I appreciate the presentation today, but I wanted to add that the FDA does permit the sterile compounding of glutathione under specific conditions. In 2022, the PCAC recommended adding glutathione to the 503A bulks list. As stated initially, the FDA did express concerns about contamination. However, ensuring the quality and purity of glutathione for sterile preparations is a core part of the current USP standard, Chapter 797. So aligning with that standard would align you with the USP, FDA, and PCAC, which are the leaders in this space. I do condemn the one-sidedness, which lacked to highlight the years of safe use in California and lives saved by access to this medication. All medication has potential risk, but part of the beauty of being an American is that we have the freedom to weigh risk and make our own health decisions. Restricting access unless a quote-unquote commercially available equivalent is absent fails to recognize that many patients have unique health needs which often necessitate specific formulations. The FDA and USP guidelines already allow for these unique cases under clinical supervision, while this proposal would limit these personalized care options. It might sound navigatable on paper, but who here hasn't struggled within the medical care and insurance system to be able to justify your needs? And we aren't talking class drugs here. Glutathione is an antioxidant. It is naturally produced in the body. Attempting to restrict it in this way is government overreach and is a slippery slope to all other supplements that Californians are able to purchase freely for now. This proposal rules add costly layers of documentation and oversight, creating unnecessary barriers to care. It discourages pharmacies, meaning patients, including firefighters, will lose access to critical treatments. It's happening already. Just yesterday during my treatment, because I'm in treatment for my years of exposure as a firefighter, my provider warned me that one of their suppliers is no longer supplying, and they're running into barriers getting compounded medications supplied to California. While not your intent,
10 seconds.
This proposed regulation is acting as a de facto ban in real life. I urge for a new motion to allow for the board to align with USP standards, allow patients to weigh their own risk. If you're not ready for that, I ask that you call a special meeting to discuss the proposed regulations outside.
All right, and time is up, so we will be moving on to our next individual. I have a call-in user 4. You'll be given 2 minutes to speak and a 10-second warning. You'll press *6 on your device in order to unmute, so listen for that prompt. Right, and calling user 4, you'll want to press *6 on your device in order to unmute yourself. Right, looks like maybe they stepped away temporarily, so that will save them in the queue and move on to our next individual. Next, I have Tennille Davis, and Tennille, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Me?
Yes, we can hear you.
Great. Thank you for the opportunity to speak today. My name is Tennille Davis, and I'm a board-certified sterile compounding pharmacist, and I'm here on behalf of the Alliance for Pharmacy Compounding and the compounding pharmacists serving patients across California. While we appreciate the board has made some adjustments to the proposed compounding regulation, critical issues remain. The current proposal threatens patient access to specialized dosage forms and strengths of compounded medications like methacobalamin and glutathione for various reasons, including the requirement for only allowing compounding under USP Category 3. We are especially concerned to hear that if these proposed regulations are not adopted, the board does not intend to allow future compounding with these substances, implying that these preparations are non-compliant with FDA standards. However, this is not the case. It's important to recognize while these API are not on the FDA's final books list, they're on an interim list that the FDA currently permits for compounding as they undergo evaluation. The PCAC has already reviewed these API and voted to include them in the final books list. We're only awaiting FDA's final formal rule publication, and compounding with these API is allowed in all 49 other states. There exists in the marketplace API other than dietary supplement grade. For example, one wholesaler says EP or European pharmacopoeia grade glutathione and methacobalamin that's graded for use as an API. The presentation that was delivered by board staff showed some instances where compounded preparations caused patient harm. It's important to investigate the root cause of any such instance and implement strategies for prevention. At the same time, all professions have bad actors or people that make mistakes. Using only those instances to create regulation that will restrict patient access is not appropriate. The example given in the presentation about patient harm in California from a product compounded that contained excessive levels of
10
endotoxins
seconds.
presents an example of a pharmacy not following current guidelines and does not demonstrate that increasing standards would improve patient safety. We're asking for a special meeting to address and clarify the ongoing
This
issues
is the
that
moderator.
remain.
Time is up.
Thank you.
For the comments.
All right, this is the moderator. I'm going to go back to call-in user 4 with area code 209. I'm going to request to unmute your microphone. You're going to press *6 on your device in order to unmute yourself. And call-in user 4 with area code 209. You'll want to click *6 in order to unmute yourself. All right, perhaps they are still away. In that case, I will move on to our next person, Richard Dang. And Richard, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Association, we would appreciate moving over to an open comment period as we are currently working with our compounding special interest groups, and we've already identified at least 13 items that we would have comments for revision, as there are several items that have either inconsistencies or lack of clarity that we would like to address, and we will submit those in written comment format when the time period opens up. Thank you.
Thank you for the comments.
All right, and this is the moderator. Next, I have Dr. Rebecca Shalev. And Dr. Rebecca, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device. And Dr. Shalev, you'll want to click that unmute me button when the prompt appears on your device. I'll request unmute again. All right, perhaps she stepped away. So in the meantime, I'll move on to Sarah Johnson. And Sarah, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device. Oh, 1 second, I lost you in my attendee list. There you are. Apologies, the attendees list is like jumping up and down for me.
I'm Sarah Johnson, and like tens of millions of Californians, I'm disabled by long COVID and ME/CFS. I appreciate the info presented today. Many of us are aware of these details and they've informed our position, so I'm glad you're taking our participation into account. No one wants patients harmed from bad medications, and as stated, FDA-approved products still cause adverse reactions, like in my own experience that caused my current disability. But we're just trying to get well, and ultimately regulations have to be written in a way to facilitate access to safe treatments we have and not eliminate them entirely. There is in fact copious and recent data proving the antioxidant efficacy of glutathione from places like the Center for Mitochondrial and Epigenomic Medicine at CHOP in Philadelphia and renowned researchers like Dr. Ron Davis at Stanford. As stated, it comes down to profit. No one is going to fund a large-scale double-blind study of a generic substance that won't be marketed as a patented brand name drug. If it's a challenge to protect the public by preventing insanitary compounds while supporting access to effective treatments, that's why you guys are there. You were each appointed by the governor as the best people to do this. Thank you to Dr. Thibault for your visibility and advocacy. You said that people with chronic illnesses and disabilities are always an afterthought. Thanks to the board for providing a roadmap for compounders to follow to the extent that it might facilitate our access to these treatments. Please continue to do whatever it takes for us to access these treatments in a safe way. Thank you.
Thank you for the comments. Sarah, I was hoping that the list would be finished before 12:30. But
Unfortunately,
naively,
yeah.
it's probably not going to happen. I'm so sorry. After this comment, we'll probably have to take a lunch break. So please stay in the line with your hand raised, or you can re-raise the hand after we return from lunch, which will be around 1:15. So go ahead.
All right, this is the moderator. I'm going to try Dr. Rebecca Shalev again. And Dr. Shalev, I'm going to request to unmute your microphone. You'll be given 2 minutes to speak and a 10-second warning.
Hi, can you hear me?
Yes, we can hear you now.
Yay! All right, thank you. Hi, my name is Dr. Rebecca Shalev. I'm a licensed naturopathic doctor practicing in Northern California and Washington. I think everyone in attendance can agree that we are all motivated by patient safety. No one is suggesting that California lower the safety standards for compounded medications. Rather, we are simply asking the board to adopt the national standards as most other states have done. Compounded medications are safe under the national standards. These standards were put into place for a reason. The horror stories that a previous speaker today cited are red herrings. For example, the patient who died after receiving IV curcumin in 2017 was determined to have been affected by a severe allergic reaction, not by any contaminant in the compounded medication. Many of my patients rely on compounded injectable medications, especially when they have an allergy to an ingredient in a commercial preparation or when the commercial drug is not available. By having separate standards from the rest of the country, it makes it exceedingly difficult for sterile compounders to do business in California, and as a result, they simply refuse to ship sterile medications to California. For me as a doctor practicing in 2 different states, I see this juxtaposition impacting the care of my patients on a daily basis. Already, my Washington patients have so many more options for treating their complex chronic illnesses than do my California patients, and this makes me so sad. Patient safety needs to include safe and effective treatment options. Thank you.
Thank you for the comments. So this is a good time. As announced earlier, we'll take a 45-minute lunch recess and we will return at 1:15. You all are more than welcome to stay in line and your hand raise or return at 1:15 promptly to raise your hand again to speak. Please stay in line. Thank you for your patience as we go through this process. We'll be back at 1:15. Thank you, everybody. We're coming back from lunch. Appreciate everyone's patience. And we'll take quick roll call to establish a quorum. Jesse?
Here.
Thank you, Renee.
Here.
Thank you, Renee. Jeff?
Here.
Thank you, Jeff. KK? Yeah, okay. Jay?
Here.
Thanks, Jay. Satinder?
Here.
Thank you. Maria? Is Maria not back? Oh, okay. Okay. Nicole?
Here.
Thanks, Nicole. Jason is coming back. And I am here. Just in the respect, make sure everyone's here. I'm going to probably wait until she comes back. And KK. So bear with us. Just for WebEx folks on there, we're just waiting on a couple board members to return from lunch break. Sorry for the delay. There's Maria. All right. 2 members are returning. Little did they know we're waiting for those two.
A walk of shame.
Okay, KK. Thank you, Maria.
Here.
Thank you, Maria. Okay, we're all here. We're ready for resuming our public comment in WebEx. Again, thank you everyone for your interest in this meeting and appreciate all your comments. Sarah, you ready?
Sure. I'm just going to give another quick reminder just in case anyone forgot during lunch. Just a reminder, when you are unmuted, to just give a couple seconds for your audio to connect so that your beginning statements aren't cut off. So we'll start back up. Next, I have James Miller. James, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, can you hear me?
Yes, we can hear you.
Okay, my name is James Miller, 34 years in the fire service as a volunteer and a career firefighter in Sonoma County. I'm also a current member of the International Association of Firefighters. I retired last year and participated in a 12-week lifelong detox program. When I received my baseline lab test results, I was horrified, but not surprised on the high toxins that are cancerous in my body. Obviously, through the emergency response and now the protective equipment we wear every shift to protect us are cancerous. At the end of the 12-week program, all my levels on my last test were down by a quarter readings across the board. 6 weeks after the program, I had lab tests from my own health provider, and my liver count was at the lowest it's ever been, along with my breathing and detox in general. Glutathione worked as intended, getting the toxins out of my body. 0 side effects on my part. The board's purpose is to serve the public by protecting the health, safety, and welfare of the people of California with integrity and honesty. If banning glutathione, you're falling well short of your responsibilities. There needs to be a special meeting so we can go over more information to be provided. Thank you.
Thank you for the comments.
All right, this is the moderator. Next, I have John Gray. And John, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Thank you. This is John Gray, registered pharmacist with Kaiser Permanente. Kaiser Permanente supports common sense compounding standards that promote the preparation of safe and effective compounded drug products, which is the reason that we support the adoption of USP compounding standards for non-sterile and sterile drug products. The USP expert committee that developed the USP compounding standards was composed of 15 members from various disciplines, including healthcare practitioners who have expertise in things like sterile and non-sterile compounding, veterinary compounding, aseptic technique, microbiology, environmental engineering, analytical testing, as well as 6 non-voting government liaisons, 4 from FDA and 2 from CDC. The expert committee spent 10 years considering the scientific evidence and stakeholder input to develop the USP compounding chapters that are now published in USPNF. We believe that any state compounding regulations that exceed the requirements in the USP compounding chapters should, like the USP standards, be supported by high-quality empirical evidence. Throughout the rulemaking process, the committee and the board have failed to provide a shred of evidence that the proposed compounding regulations, all of which exceed USP standards, are likely to have any desirable impacts on the compounding of drug products that are prepared and dispensed to California patients. I have read the initial statement of reasons, and I can confidently say that at best the board has cited vague concerns based on past inspections of individual pharmacies, which is anecdote, not evidence. Today, the board engaged in extensive discussion on the lack of evidence for certain compounded drug products. However, the board has still not presented any evidence that its additional regulations are necessary to protect the public. For these reasons, it is clear to us that the board has failed to meet its obligation under the Administrative Procedures Act to provide substantial evidence of the need for the proposed regulation. Therefore, we continue to encourage the board to withdraw this rulemaking package and initiate a new rulemaking to repeal Articles 4.5 and 7, Division 17, Title 16 of the CCR, and simply rely on existing requirements in the pharmacy law that pharmacies comply with the evidence-based requirements in the current compounding chapters of USP. Thank you.
Thank you for the comments.
All right, this is the moderator. Next, I have Grant Miller. And Grant, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, my name is Grant Miller. I am a veterinarian and the Director of Regulatory Affairs at the California Veterinary Medical Association. I'd like to direct your attention to Section 1735.1 E2 and 1736.1 E2 relating to the use of compounded medications, the use of bulk ingredients when compounding medications for veterinary use. Currently, those sections make reference to the Animal Medicinal Drug Use Clarification Act, or AMDUCA. And while AMDUCA is applicable to those sections, AMDUCA is not as specific as those sections should be, by our opinion, because it provides general information about circumstances under which compounded drugs can be utilized, can be made for animals in an extra label fashion, and talks about labeling and record keeping and whatnot. But more importantly, there should be a reference to the FDA's guidance for industry number 256 in both of those sections that came out in August of 2022 and is an inclusive list of drugs that may be compounded from active pharmaceutical ingredients. And those are very important to us, and we'd like them definitely mentioned in this law so that licensees can clearly understand that it is still permissible to utilize those to provide needed medications for veterinarians to use in their patients. Thank you.
Thank you for the comments.
All right, this is the moderator. Next, we have Michael Blair. And Michael, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Hi.
in support of what Dr. Miller just said. Section 1735.1E2 and 1736E2 of the proposed regulations provide in part, and I'll paraphrase, that no compounded preparation shall be prepared that is made with any component not suitable for use in a compounded preparation for the intended veterinary population, unless allowable under the Animal Medicinal Drug Use Clarification Act, or AMDUCA. The phrase "not suitable for use in the intended patient population" in the proposed regulations is ambiguous and confusing. Many bulk drug substances have been used in medications to treat animals for decades and are regularly prescribed and ordered for office administration by veterinarians treating their patients. Is regular use by patients without incident the standard the board will apply in determining suitability for use, or is there some other standard not written in these regulations that the board intends to apply? In addition, the reference to AMDUCA in the regulations is both ambiguous and inappropriate. AMDUCA, as passed by Congress, allows for off-label use of animal and human FDA-approved medications in animal patients. Prior to the passage of AMDUCA, prescription medication could only be used exactly as labeled, that is, no off-label prescribing. Section 530.13 of AMDUCA provides that nothing in this part shall be construed as permitting compounding from bulk drug substances. Notable and relevant for this discussion, in no way does AMDUCA directly prohibit compounding for animal patients from bulk drug substances. Because AMDUCA does not address ingredient suitability for use in a compounded preparation, its reference in sections 1735.1 and 1736.1
10 seconds.
confusing. We believe that references to AMDUCA in the proposed regulation should be removed or revised in a way that provide clear guidance to pharmacies. Thank you.
All right, this is the moderator. Next, I have Lucas Evenson. And Lucas, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, my name is Lucas Evenson, and I'm speaking on behalf of the California Medical Association. If the current motion carries, CMA will continue to request that the proposed language be amended to include explicit language that clarifies that the regulations do not apply to physician compounding, and will submit a letter to that effect. The current regulatory language expressly states that the standards and restrictions of the regulations apply to activities occurring in a pharmacy by or under the supervision of pharmacists. Based on board member comments made in various meetings on the subject and the initial statement of reasons, we believe that it is not the board's intent that the regulations apply to physician compounding, and yet, as you continue to hear in these meetings, the proposed regulations are causing confusion about the applicability in the physician community because they impose standards on compounding without specifying the setting of care or type of licensee. Ensuring clarity is critical because the language as currently written, if applied to physician offices, would impact direct patient care. Thank you.
Thank you for the comment.
All right, this is the moderator. Next, I have Andre Peters. And Andre, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Can you hear me okay?
Yes.
Good afternoon, Andre Peters, Director of Pharmacy for Regulatory Compliance Medication Safety at Scripps Health. We share the mutual goal of keeping patients safe, and we want to thank the board for making substantial changes already, and thank you for hearing us. We also thank you for what I notice is a renewed level of engagement with the public, which we haven't necessarily seen in the past, and I would like to encourage the board to continue on this collaborative path. I think in the process of us assessing the need for additional rules, please make part of the process an assessment of any rules stricter than USP, whether it's really necessary, or is it one of those only nice to have type of rules? some of the existing regulations have been problematic since the way that since when they started, and we've learned over time that these rules don't serve us well, and I think we need to make sure that going forward we remove those rules and put forth something that makes sense. I want to ask the board, please guard against overregulation and nuisance regulations. Regulations that keeps us engaged in documentation and keeps us away from caring for patients. I do want to say that I agree with the motion for 30 days comment period and the ability to comment on unmodified text. Thank you for all you do, and I appreciate the opportunity to provide comments.
Thank you for the comments.
All right, this is the moderator. Next, I have call-in user 31 with the area code 808. Call-in user 31, you'll be given 2 minutes to speak and a 10-second warning. You'll want to click *6 on your device to unmute. All right, call-in user 31, I'm going to request to unmute again. You're going to press *6 to unmute yourself. All right, perhaps they stepped away. In the meantime, I will move on to our next commenter, Lou Storzinger. And Lou, you'll be given 2 minutes to speak and a 10. Oh, never mind. I apologize. We got connected with calling user 31.
Sorry about that.
No worries.
So my name is Stephanie Ensley. I'm a captain with Goldridge Fire. I've been a firefighter for 20 years. I was part of the what would you call it? Testing that was done last year along with other firefighters you've heard from already today, where we went through 16 weeks of glutathione treatment. And as a person who watched my own father die of cancer and seeing and watching him go through that and seeing that my numbers were so high in toxins, I was on the same path as him. The glutathione did amazing things for me over those 16 weeks. It took me out of the danger zone, put me back into a normal person's zone who has never fought a fire, who lives a normal life. And I understand and heard the board saying they are not trying to take away treatments. They were very clear about that, and yet you've already taken away our ability to do glutathione treatments at home via nebulization. So it would be great if you'd reinstate that to back up your words. Additionally, you've got people, there's no empirical evidence for what you're doing. Your overreach is astounding. You're trying to go over FDA standards with no reason. Due to things like this, I sincerely ask you to have a special meeting and that we can go back to the drawing board and start
10 seconds.
Talking about some of these things and having a better conversation, and to give people 2 minutes to respond after a 1-hour presentation is ridiculous. Thank you.
Thank you for the comments.
All right, this is the moderator. Next, I have Lou Sterzinger. And Lou, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
My name is Lou Storzinger, and I'm a fire captain in Sonoma County. I've been on the job for 27 years. You've heard from me before, and I'm here again to ask that these regulations not be adopted in their current form. You have heard the success stories of the use of compounded glutathione and the reduction of cancer-causing toxins and the improvement in firefighter health. You have heard us speak on the importance of continued access to this medication and, frankly, to many medications that will no longer be available to Californians under the additions that you have made to the USP regulations. Additions that no other state has made, despite what the targeted screen grabs that a prepared presentation by staff suggested. A prepared presentation that was incredibly one-sided. While I appreciate the work that went into the presentation, it was generally just recycled material that was already been presented in court and disproven during litigation that was brought by the board and lost on a repeated basis. Litigation that was paid for by our tax dollars. Despite what you say, your actions will most certainly make many medications unavailable in this state under the guise of public safety. The action you are taking has brought together and galvanized many different groups and individuals to stand against the regulations. From businesses to unions to doctors to patients and advocates, we continue to speak out about this government overreach. If this is not a sign that maybe you got this wrong, I don't know what is. While I appreciate the board's stance on the matter with so many different groups involved, I could only imagine that this is not the end of hearing from opponents. And unfortunately, the continued action will most likely lead to more litigation and the waste of more taxpayer dollars when this problem could be solved now with the adoption of USP without additions and overreach. Please send this to a special meeting so that we may have an actual discussion and more than 2 minutes to refute almost 60 minutes of prepared one-sided testimony. Thank you.
Thank you for the comments. Just to make sure the board is a self-funded agency. Thank you.
All right, this is the moderator. Next, I have Lauren Salmonen. And Lauren, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device. And Lauren, you are unmuted.
Okay. You can hear me now?
Yes.
Okay, sorry. So my name is Lauren Salmonen. I'm an environmental neuroscientist and a researcher. Bione. Like many others, I only recently became aware of this proposal, and I'm greatly concerned about the amount of disingenuous information that appears to be circulating among the board, as well as what's being communicated with the public. I'm concerned these decisions are coming from a group that appears to have no substantial experience in human clinical or epidemiological research. I'm grateful to the board for extending the comment period so the presented information on patient risk can be adequately reviewed. But even without this extended time, it's clear that the patient risk data appear to be very cherry-picked science to support the overall initiative championed by the board. Some of the evidence presented were in extremely small sample sizes, sometimes only in single patients. As someone else previously mentioned, that's anecdote, not evidence. There's no question that patient health and safety is paramount, but I've seen nothing that sufficiently supports the proposed effort with regard to patient safety. For example, when there is an E. coli breakup from strawberries, the FDA doesn't ban strawberries. It isolates the source of the contamination and proceeds accordingly. Simultaneously, the hundreds of empirically reviewed research studies on the health benefits of injectables such as glutathione and methyl B12, especially in certain subgroups, have not been presented. For example, people that follow a vegan diet often have a B12 deficiency since animal products are the primary source. So this goes beyond just clinical populations. There's also no mention by the board on the added health benefits of injectable substances over oral supplements, as injectables are significantly more bioavailable in the human body. This oftentimes makes them more cost-effective given the increasing cost of oral supplements. With all of this in mind, that's just a request for more outside opinion from
10
individuals
seconds.
that have human clinical research experience, epidemiological research experience, and to adopt the existing provisions without additional modifications. Thank you.
Thank you for the comment.
All right, this is the moderator, and then just real quick before I go to our next commenter, I just want to remind people that the Q&A feature is being used as just a means to indicate that you would like to make a verbal comment. Please don't put questions in there. This is just a means for you to indicate that you would like to make a verbal comment. So next we have Jenny Harrow-Keeler. And Jenny, you'll be given 2 minutes to speak and a 10-second warning. Please click the Unmute Me button when the prompt appears on your device.
Thank you for this opportunity to speak. My name is Jenny Harrow-Keeler. I'm the co-founder and executive director of Integrative Healers Action Network. You have heard from several of the firefighters our programs have supported, and their pleas for keeping access to glutathione are urgent. And I want to address this morning's presentation on glutathione. The Pharmacy Compounding Advisory Committee, or the PCAC, reviewed the FDA staffer's testimony claiming that glutathione is dangerous and ineffective. After careful review, PCAC rejected this testimony and voted 8-5 with 1 abstaining to add glutathione to the Category 1 list. Very importantly, no committee members voiced safety concerns, and several even cited glutathione's strong safety record. Dr. Bill Calhoun, a PCAC committee member, summarized it well by saying, "The physical and chemical stability of this compound is fine. It's safe, with no risk to public health. I found the agency's review of efficacy superficial and dismissive of positive data. In order to maintain availability, I voted yes. For the past 7 years, the doctors in our organization have safely supported hundreds of firefighters across Northern California with glutathione. We have not had a single adverse reaction. As we expand to work with more fire departments across California, preserving access to glutathione for these frontline responders is essential. Please, we respectfully request a special meeting to discuss this matter further and to help ensure that glutathione remains accessible to support firefighter health. Thank you.
Thank you for the comments.
All right, this is the moderator. Next, I have call-in user 40 with the area code 707. It looks like we have a couple of 707. So the next number is next 2 numbers are 36. Call-in user 40, you'll be given 2 minutes to speak and a 10-second warning. Please click. You'll be pressing *6 on your device in order to unmute yourself. All right, and call-in user 40, you are unmuted. Oh, looks like you muted yourself again. Let me go ahead and request to unmute. You'll press *6 again to unmute yourself.
Sorry about the technical difficulties. My name is Jason Campbell. I'm a fire captain with Sonoma Valley Fire. Much like some of the others that commented, I participated in glutathione treatment recently. I am a 20-year vet of the fire service, as well as a husband to a wife who's currently being treated for breast cancer. I cannot understate the significant level of change in the toxins that were in my body through this glutathione treatment. I am also the vice president of our local labor group, and we strongly support this. In fact, our fire chief, who's not able to be on, is a almost 40-year vet of the fire service, as well on the Cal Chiefs E-Board and the president of the Sonoma County Fire Chiefs. Our fire department has put almost 25% of our full-time paid firefighters through this. So we strongly support this effort and the glutathione treatment. With that, I strongly encourage that the board please accept the USP standards instead of the proposed regulations, or otherwise hold a separate meeting on this topic with a more where a more open conversation can happen, including opening our ability to be treated by nebulized glutathione. Thank you.
Thank you for the comments.
All right, next I have WebEx user L got long COVID, and L, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
of advocacy campaign Got Long COVID. My comment is regarding the proposed regulations with respect to the broader legal and regulatory landscape in which the BOP is embedded. As attendees may or may not know, past actions of the BOP, including 8 failed predatory lawsuits against compounding pharmacies, have instituted a chilling effect for compounding pharmacies in California. Title 16 proposes additional requirements for sterile compounding preparations, which would increase operational costs, putting pharmacies at risk of going out of business or increasing prices, as owners have flagged in written comments to the board. 10 years ago, there were over 100 compounding pharmacies in California. Now there are only about 18. In the last meeting, many asked, why does California uniquely need to exceed federal guidelines to this degree? See, when there is a drug shortage, compounding pharmacies are able to bypass pharmaceutical patents to produce the drug for critical care delivery. So why exceed federal standards in California specifically? Well, the FDA-approved weight loss drug Ozempic is a compounded preparation prescribed widely within California, likely the result of the film and entertainment industry dominance in LA. As such, the drug has been subject to many shortages, resulting in pharmacies producing an alternative semaglutide compound, the same ingredient with varying formulations or dosages based on patient need. These alternatives may be up to 70% less expensive than the patented preparation, albeit only in shortage conditions. Every time a shortage takes place, Novo Nordisk, who owns the patent, loses money. This is only one example in a broader trend of pharmaceutical companies targeting compounding pharmacies over patents and profits, not patients and safety. Clearly, it is in the financial interest of pharmaceutical companies to target compounding pharmacies. But the Board of Pharmacy is not a pharmaceutical company. It is a regulatory government body. Again, I ask why? Why target compounding pharmacies? Why exceed federal guidelines to this degree? Please send this back to committee. Thank you.
Thank you for the comments.
All right, this is the moderator. Next, I have Alan on. And Alan, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Good afternoon. My name is Alan Ahn. I'm the sterile compounding manager at Cedars-Sinai in Los Angeles. Again, I'd like to really thank the board members for allowing us to provide the opportunity to discuss these proposed regulations and comment on it. And I do want to also state that I do agree with the previous speakers that have spoken before me. Well, again, thank you for educating the public on the background of the rationale behind the sterile compounding laws and regulations and why they're important. And I also appreciate your efforts on working on these with the public on the proposed regs. Some of the incidents that was provided, of course, for such as the New England compounding regs, was a definite example of patient harm, but they were really caused by companies and individuals that really did not follow the established USP requirements. In addition to that, the new proposed chapters are revised to really help further add safety guardrails for our patients. These chapters are sets of guidelines that are really evidence-based and should provide the safe compounded medication for our patients in California. If not so, other states such as Michigan, Illinois, Indiana, Iowa, they would not have adapted these regulations as, part of their compounding law. I fear that as some of the speakers has said, I fear that the overregulation could really cause patient harm due to the potential delays that it could cause. I urge to the board if they could please consider redacting the old compounding laws and utilize the USP as our compounding law, as many states have done so already, or if not, give us the option to really comment on these unrevised text as well as a new text for maybe an additional 30-day comment period. Thank you again for the board for allowing me to provide comment. Thank you.
Thank you for the comments.
All right, this is the moderator. Next, I have call-in user 43 with the area code 707. Next numbers being 331. You'll be given 2 minutes to speak and a 10-second warning. You'll click *6 on your device in order to unmute yourself.
Hello, my name's Mike. I was recently in a detox program using glutathione. Thank you all for giving me a chance to speak today. As a firefighter, I know firsthand how demanding our work can be on our health. I started using glutathione and I've seen a real difference in my lab results and overall well-being since then. My wife, who's an NP, nurse practitioner, has reviewed the data as well. Obviously before I signed up for this, and excuse me, finds no good reason to restrict access to it, especially given its natural role as an antioxidant in our body. Here's what I don't understand, though. If these regulations are so critical, why hasn't a single stakeholder come out in favor of them? Not one doctor, pharmacist, patient advocate, or hospital representative has spoken up to support these changes, even voice in opposition. To me, that raises a serious question about the necessity of these regulations. On top of that, why should we lose the choice to use a supplement that clearly benefits our health, especially when there's no strong evidence of harm? For people like us, this is about having options to protect our health in ways that work. I'm asking the board to adopt the USP standards and FDA regulations that allow compounding glutathione across the country. And if the board isn't ready to make that call, then please consider a special meeting to fully discuss these regulations. Thank you very much for listening. I know it's been a long day for everyone, but this issue impacts
10 seconds.
not only the health and safety of firefighters, but everyone who relies on the supplement.
Thank you for the comments.
All right, this is the moderator. Next, I have call-in user 44 with area code 707, and you'll be given 2 minutes to speak with a 10-second warning. You'll click *6 on your device in order to unmute.
Good afternoon, ladies and gentlemen. My name is Tommy Lowen. I'm an engineer, firefighter in Sonoma County. Today I'm speaking not only as an advocate, but someone who stands shoulder to shoulder with all of who put their lives on the line in service. I'm here to talk about a breathing medicine that can make a life-changing difference for firefighters like us. A medicine that addresses one of the greatest risks we face on every call, the threat to our lungs. We know the hazards and we walk in and accept them, but the toll smoke, toxins, and heat take on our lungs is real, and over time it adds up. This breathing medicine is designed to help with exactly those challenges. It's not just about treating symptoms, but helping our lungs recover and clearing airways and reducing inflammation and strengthening our overall respiratory health after each exposure. Imagine what it could mean to be able to take a medicine right after a long day of fighting a blaze. To that, it works to clear your lungs, letting you breathe easier, helping to prevent chronic damage, and ultimately protecting your ability to keep doing the job we love. We're the ones that rush in and help others to rush out, and we shouldn't have to sacrifice our long-term health to do it, but we do anyway. These breathing medicine could be a lifeline, not only for us out there every day, but for every firefighter in California who comes after us. It's a way to ensure we all get to go home safe, and not just in the short term, but in the long term. So let's support this breathing medicine for firefighters, not just because it's a treatment, but it's also a commitment to each other's health and safety. Let's advocate for it so that every firefighter has access to the best possible tools to protect not only others, but also ourselves. Thank you.
Thank you for the comments.
All right, this is the moderator. Next, I have Isaiah. And Isaiah, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device. All right, and Isaiah, if you wish to make a verbal comment on this, go ahead and click the unmute me button when the prompt appears on your device.
Oh, I apologize. I didn't realize that I had pressed for my turn. I spoke the last meeting back in September, I believe, about how many patients that I help out. I work at a naturopathic medical clinic. Went to school for fitness nutrition and work with naturopathic doctors. And we've done a lot of great work with methylcobalamin, with B12, with glutathione. And we have so many patients that we treat with digestive issues. And so having this shortcut of intramuscular injections, even IVs, has been a really great problem solver to help people with these chronic conditions, with digestive issues and other things, to help them to catch up quickly with what their bodies aren't able to produce on their own. Last time I talked about MTHFR, people not being able to methylate on their own. So the methylcobalamin is such an important factor of B12. So just B12 alone is not enough for people with this issue. And a third of women in the US population have this issue of methylation, which causes so many problems, fatigue, and so many other issues that they deal with. And so having this form be in methylcobalamin is so important for them. And then with all the firefighters and the detoxification, but it's not just the firefighters. I think that there's an overwhelming amount of firefighters that really know, how much this is impacting them, and they're so appreciative for this. And to take that away is, terrible. But there's so many other people that this has benefited them in so many different ways. And so I know that the intention is not to take away, but that's exactly what is happening with the way that the words have been set up with everything that I've heard from last meeting to this.
10 seconds.
And so I really appreciate the formality of the presentation that we heard earlier, but it just it doesn't make sense to me, and you're going to be taking away so much good from so many practitioners.
All right, and time is up.
Thank you for the comments.
All right, this is the moderator. Next, I have Chad Baker. And Chad, you'll be given 2 minutes to speak and a 10-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, everyone. This is Chad Baker with FlavorX again. My apologies for not being there with you in person today. I simply wanted to say thank you to Member Crowley for bringing up medication flavoring today in the discussion. It's very encouraging to see you keep this important topic top of mind with the board. I also wanted to thank Member Serpa for her comments on working together with all interested parties to come up with a pragmatic policy to bring medication flavoring back to California's pharmacies. Those comments were very much appreciated. I and others definitely look forward to working with you to help develop said policy whenever that time may come. So that's all I've got for today. Thank you.
Thank you for the comments.
All right, this is the moderator. It appears that was our last request for public comment. Would you like me to close that Q&A panel?
Sure. Thank you. Okay, members, bring the discussion back to the board. I know that this is a very emotional issue for a lot of people. As the presentations highlighted, though, the action is required by the board to address many of the comments, including a means for pharmacists to compound substances such as glutathione and methylcobalamin. Without regulations in this area, as the board identifies pharmacies engaged in such practices, it will continue to assess on a case-by-case basis compliance with federal law, national standards, practice issues of the specific site, and potential harm for patients as well, et cetera, et cetera. So with that, any comments, members, before we vote?
I just wanted to thank everyone for their comments and to summarize a few things. I speak in support of having a 30-day comment period. I think we need to continue this discussion in the formal process. I would love to have people submit their written comments so that it could be addressed individually and you actually get a response and it'll be public and everyone can read the comments. So I support the motion for a 30-day comment period. I also wanted to repeat one of the things that Anne noted in her presentation is we cannot solely rely on USP, as we currently have regulations in California that are higher than USP. And by repealing those regulations and solely relying on USP, not only would we lower patient safety standards in California, we would have gaps. And those gaps were identified in the slide that Anne proposed that said that the USP defers to the state. So that's why we need to have regulations in the state to fill those gaps and to maintain the current safety standards that we have with current regulations. We hear, just to kind of remind everyone on the board particularly, but also for members of the public, almost all of the testimony is about one section of 1736. There are 1735, 1737, and 1738 that we haven't talked about for a long time. So hopefully when you read the materials, you read those too, providing safety parameters for things like pediatric suspensions. We have millions of pediatric patients that get compounded products that are oral. Chemotherapy. We have, I mean, everyone knows somebody who's been on chemotherapy or has had chemotherapy themselves. These standards in USP and the clarifications in our regulations are to provide safe chemotherapy for patients that are undergoing some of the toughest battles of their life. I understand that's true also of those that have chronic diseases, but I just wanted to remind you of the people that we haven't been talking about. We also have a whole section that's about radioactive tagged medications. Again, these are people who primarily have cancers or other types of diseases that require radiation therapy and tagged medications. We have not talked about that at all, but that's a big part of these proposed regulations also. So if you look at USP and you look at what the board is proposing in all these other areas, you can't just throw them all away. And so when people say go back to USP, I'm very concerned about that because not only is it not addressing all these other areas, but it's also lessening our current regulations that we have, some of them going back to 1986. Additionally, much of the proposed language, just to repeat, because I know I said this before, is a rewrite of the current regulations that we have. 45 pages of current regulations are being rewritten into the format that makes it easier for licensees to understand in the order that's numbered by USP. So while it looks like a lot of new information, a lot of it is just a rewrite of the old one that's being repealed. One of the additions has caused a lot of confusion, and that's where we hear a lot of the testimony, and that's on Category 1 bulk drug substances. But if you look at the details of what's being added in that area, it's just a repeat of FDA and USP requirements to assist licensees to provide safe substances in a safe manner. It's a providing that the product is using safe, tested, and free of endotoxins as much as it can be and contaminants, that the chemical that's being used is safe so that the product is safer for those who need it. We're not trying to eliminate access to glutathione, methylcobalamin, or products like that. We cannot do what the FDA's role is. And just to remind everybody, the FDA's role is to determine the efficacy and use of products. Nothing in the board's regulation talks about efficacy and use of products. It talks about if you are going to compound, how to do it safely. The other parts about efficacy and use is all on the FDA. And I really do appreciate everyone's thoughtful testimony. And some of it is, really tugs at your heart because these are people who are suffering. I encourage you to write to the FDA and to your representatives to get the FDA to actually move it to be an approved substance. There's nothing to stop them to do that. As many of you have heard, the committees in the FDA move very slowly, and that's why we're kind of stuck in this process. But the board is not telling you if you can use something. It just says if you're going to use it, it must be compounded from a safe product in a safe manner. And lastly, I know I've talked a lot. I'm looking forward to discussing flavoring. I think that that's an opportunity. So we really need to have a 30-day comment period, and I support the motion. Thank you.
Thank you, Maria. Thank you for putting it so eloquently. I really appreciate you summarize many of the thoughts I have. Jesse?
Thank you. I'll be pretty quick. The first thing that I wanted to address was the hazardous drug handling. So I know we had discussed in the past that, of course, the focus of this is on compounding, but I will say from the retail perspective and having worked in several retail pharmacies across California, there is a lack of understanding of handling anti-neoplastic medications. And so I think it's actually vital to keep that language in here so that people who are just manipulating it, whether it's cutting the tablets or pouring it from one bottle to the other, know how to do so safely, not only to protect the area that they're working with when they're handling other medications, but also for the safety of the employees who work there. And then lastly, I just wanted to extend my appreciation for the recognition that the process for approving medications through the FDA is long and expensive. I think typically, you know, in pharmacy, we tend to have a very Western view of medicine. And unfortunately, it is the case that a lot of things that maybe not considered traditional Western medicine or maybe cheaper, there's a lack of money to be made in that aspect. With that being said, I think the language presented really does provide a safe pathway moving forward so that patients can continue getting the medications they need. And I am in support of this motion.
Thank you, Jesse. Any other comments, members? Okay, seeing none. Are you sure? Okay, ready for a vote. I'm gonna go for vote myself. I vote yes. Jesse?
Yes.
Thank you, Jesse. Renee?
Yes.
Thank you, Renee. Jeff?
Yes.
Thank you, Jeff. KK?
Yes.
Thank you, KKJ.
Yes.
Thank you, Jay. Satinder?
Yes.
Thank you, Satinder. Maria?
Yes.
Thank you, Maria. And Nicole?
Abstain.
Thank you, Nicole. And Jason? Thank you, Jason. I vote yes. Motion passes. Thank you, everyone. I'm looking forward to the amended text as we continue to move this process through the regulatory path, and looking forward to seeing all the comments and working on all those responses to the comments
President O,
received.
could I make one comment?
Sure.
Just to provide some education, because I know the regulatory process is very complicated, is there'll be a notice as to when the board is receiving comments. And there'll be a 30-day period starting at the beginning of that notice. It's important to keep track of that information so that your comments make it into the record, that everyone will have access to see. And I think if people submit a comment early, what happens to it? Or Noreen?
If comments are submitted prior to the issuance of the modified text, then the board could choose to respond to it, but is not required to. But then it's also not clear whether or not the comment actually is referring to the modified text. So there creates some lack of clarity there.
So I would imagine that please keep an eye out for the announcements, the modified text as of August 29th, 2024. That text is a text you can comment on. There will be an email and they will post it on the Board of Pharmacy's website. Please submit written comments. Verbal comments are appreciated as well, but written comments can really explain your thoughts, and that please share that with us. With that, I appreciate everyone's time and dedication to this effort. I really appreciate everyone here, especially all the board members as well as staff, and Corinne, our counsel, Noreen, Corinne, just realized that they rhyme well together. Thank you guys. I appreciate all of you, and the meeting is adjourned. Thank you, everybody.